Brother Isaiah again with another one for all the conscious brothers. Like they're trying to mess with the mic too. And all the conscious sisters in the conscious community keeping the struggle because we know that it's through struggle that we grow.
Absolutely, Andrea. So the page you're looking at right now is all about joining the
Peace and love, family. Peace and love. How's the family? Everybody good? Myself, I'm blessed. I'm taking everything in step stages and degrees. Constantly unfolding in the womb of the world. Everything. Uh, Today, I just wanted to, we're going to talk about a little extortion practices, right? As you should know, that uh, credit is the order of the day. And the government, the United States government, is the creditor, all right, over the society. The people, we are the borrowers, right? But we're borrowing through a legal capacity, right? Like a pass through entity. So it's very important that you understand your legal relationship with your state government, right? Because the state government where you are located is responsible for any U.S. obligation. So understanding how insurance works, right? So the government is the insurer, right? What they do is they insure all of the people, right? The way that they insure the people, every man or woman has to be a resident, right? Through a legal person. So all residents are recognized as insured individuals because a resident will be consisted of a legal person and a natural person legally intertwined together as one unique entity created for personal, family, and household benefit. So, a Sesta KV trust is a man acting as a legal entity. That's what a Sesta KV trust is. It's actually a legal entity used as a identifier for a man to use to identify his rights or her rights for goods and services. So when you're operating through your Sesta KV trust, you have protections. All right. I want you to change your concepts in the way that you see commerce because you got to understand that once you walk outside your house and you leave your front porch, you're in commerce. You're in a commercial venue. Everything around you outside your house is public. The public is the commercial venue. So when you go out into the public and you're operating in a commercial capacity, whether you recognize that capacity as commercial or not, the social security number and the legal name is a national identifier. Okay. When you're utilizing a legal name, let me pull this up on the screen. If I'm on YouTube too, right? So you go to the YouTube, you can see what I'm pulling up. So I'm gonna look up the SSA definition of legal name. All right. Now, if you've been studying this stuff long enough, man, you should really come to a real understanding of what's going on. So, a legal name, according to the Social Security Administration, is defined as a given name, which is the first name, and a last name, which is the family name. So, commercially, when you're utilizing your legal identity, your first name in your legal name will be your given name. And the last name in your legal name will be your surname. Okay. So actually, your legal name is composed of your given name and your surname put together in order to create a legal identity from both parents, because you have two separate names. One comes from father, family, and then one comes from mother, given at birth. By law, those are two separate parts. You can't really put them together as if they came as one, because they did. They came from two separate parts. But when you're doing business, they combine both parts together to legally identify who's using this legal identity. So what they did, in order for you to be identified, they made the legal person the surname and given name of a man. So when the man comes forward, he can use his name in the surname and given name capacity. He can come and say, hey, I'm Bay, comma, Isaiah Jakeem, acting as Isaiah Jakeem Bay, the legal person. So your surname and given name should verify the legal person's identity, because legally that legal name is a surname and given name combined. So when you come forward and you claim ownership, you should be coming in your surname and given name, which should verify the legal identity, because the legal identity is composed of surname and given name. So if you're coming forward as a man saying you are Bay, comma, Isaiah Jakeem, which is a surname and given name, and you're making a claim that you are acting as the legal person or the buyer or the leasee, okay? Because the leasee is the legal version of your name. But when you make the claim, you got to make the claim from the natural standpoint so they can know that it's the proper person making the claim, because the proper person to make a claim against that legal name should be the surname and given name of a man. It should be the man stepping forward saying, hey, that legal identity is representing me. I'm the one acting under that title. So when you understand your government name is a title, it's very important that you understand. Now, I'm going to pull up the legal definition of title, right? Because I want you to understand something, right? We at a time now where we really must study to show ourselves approved. And those of us that have knowledge, like a brother like me, our job is to teach our people, is to each one teach one, to bring us up to a level of consciousness. Of course, you're going to have Africans, you're going to have Europeans, you're going to have all these different races of people trying to get in on this divine vibe that's going on right now, because you got a lot of people that look like me that are getting downloads, and it's evident. You look around you, you see more information coming from us than you've ever seen in your life, from medical, from history, from UCCs and commercial law. We are on a higher peak right now than we've ever been when it comes to this information, and people can see that. And none of us ever went to school for none of this. Most of the people that's teaching this stuff, ain't none of us got no high school, college degrees or none of that. We certified from the creator. The knowledge comes through source. See what I'm saying? Now, I don't need to go to their college to figure out how to operate, because the source gives me that knowledge. All right. That's why they hid everything from us. They made sure we didn't get the proper education so that we can be subservient to them and they can be the employers and we can remain employees, not understanding how the system works. So it was like a win-win situation from them, is they can keep us blinded, deaf, and dumb, and keep a society wrapped around us with rules and regulations that we so caught up in the rules and regulations we can't see outside of that stuff. So we get boxed in. But I want you to look up the legal definition. All right, so let me finish with the legal name. So before I go into that, so the legal name consists of the surname and the given name, right? And that is used to sign legal documents such as deeds and contracts, right? So your legal name is an administrative name, all right? And that administrative name is only used to enter into legal contracts and administrative agreements, right? So now we're going to look up administrative name, legal definition of administrative name, okay? Because I want you to learn how to unravel the mystery, because they call it a legal name. But when you look up a legal name, it says a name used for administration. So let's look up in administration, the administrative name, right? Look of administrative. All right, I'm just showing you what all I'm doing as your brother. I'm showing you how to look from different angles at the same. Like instead of looking up legal name, it's going to give you a certain definition. But when you read the definition, it says administrative name. So it would be proper if you want to fully comprehend what it is to look up administrative name too, so you can get a better understanding what a legal name is. So I'm going to look this up and we're going to see what it says. Okay. So including for Social Security administrative name change, right? Now this is what it says. Oh, stop playing with it. Now my thing want to go the opposite way when I'm telling it to go one way. It's going, all right, so the Social Security Administration, SS, defines an administrative name change as the process of updating the individual's name on their Social Security record after the legal name change, such as marriage or divorce. I didn't ask, oh, I said administrative name change. I didn't ask for a name change. Administrative name, my bad, y'all. So an administrative name as defined by the Social Security Administration, SSA, refers to a legal name used to sign legal documents, deeds, or contracts. It consists of the first name and the last name, which is the family name, that is used for official purposes. The SSA, right, does not consider the middle name or suffixes like junior, senior as part of the legal name, right? Meaning they can be omitted, meaning removed, or included in the name shown on the document. So your prefixes, your suffixes on your name, like junior and all the senior and all that stuff, don't have to be added, right? None of those things have to be added to your legal name. So if my name is Isaiah Bay Jr., right? My real name is Isaiah Joaquin Bay. Junior don't even really matter. That's just something we throw on there to say, oh yeah, he named after his father. But at the end of the day, your name is your name. Yeah, junior, senior is just some add-on stuff, right? Your name is your name, right? Now, what's important about what we just read? Well, what we're reading on the screen is about the administrative name that a Social Security Administration, which gave you your legal name, right? They say that it's only for contracts. So understanding what a legal name is, an administrative name, you're doing administrative acts. Okay. So this says that it's used for official purposes. So now I'm gonna look up legal definition of official purpose, because you got to be certain today, man. You can't be guessing, can't be assuming, and you must learn how to read and extract information from what you're reading. So now we're gonna look up the legal definition, SSA definition of official purpose. All right, so the Social Security Administration, SSA, is an independent agency of the federal government responsible for administering Social Security, which provides retirement, disability, and survivor benefit. It is an official purpose is to promote economic security of the nation, people through uh, compassionate and vigilant leadership in shaping and managing America's Social Security program. The SSA manages various programs, including the old age, survivor, and disability, right? So the official purpose of this SSA is to provide benefits stuff to the people, right? So we're going to take off the SSA part of it. I'm just going to look up the definition of official purpose. The term official purpose refers to an action or a reason that are or reasons that are recognized or sanctioned by an authority, right, or organization for the performance of their functions. It can include assessing federal facilities, board federal regulating commercial aircraft entering into nuclear power plants, actions taken by government entities or organizations for the purposes such as improving public service, enforcing laws, or managing. So, right, so an official purpose, right, is for whatever purpose that you need it for. So a legal name is used for official purpose, right? So administrative purposes. So what that means is, in so many words, you've been using your name wrong. Let me explain to you why. All right. So if a legal name, which is your government name, and we all know it, that it's our government. We constantly refer to it when we talk to each other as a government name. We know that it's a government name. We'll even tell each other, man, don't give my government out, man. Stop using my government. So we know what it is. We just haven't took the time out to fully comprehend the meaning behind it. We know that it's a government name, but in our mind, because it's spelled the same, pronounced the same, and it looks the same as our personal name, we just assume, just from the sound pronunciation, that that's our name. So we're not actually going off of facts or actual style and presentment. We're going off of sound. When we hear the name, that's what we go by. Hey, Liddell, oh, you turn around, that's me. Isaiah, that's what you're going off of. You're not looking at the style of the names on the paper. You're not doing none of that. Because if you was, you'll have a different understanding of how to deal with situations, right? So a legal name is used for legal and administrative purposes. You got to understand what that means. What is a legal or administrative purpose? A legal or administrative purpose is anything you legally do. So if it's legal for you to go out and get a job, right? And that's a legal right you have. Then the government gave you citizenship. Citizenship is a legal right to enter into contracts and agreements. Let me break it down for you because you don't understand citizenship. Citizenship don't make you bound to the U.S. government like you are their slave. Citizenship is an accumulated right to enter into contracts and agreements through a legal identity that legally identifies you as the proper person to use that information. Okay, so when you go out and you enter into a contract, right, and you're using a taxpayer as your legal identity, you're not supposed to be signing your personal name because you're not acting personally at that time. You're acting as a taxpayer. Do you understand what that means? I don't think you really understand what that means, because if you understood that you were acting this whole time and that not once were you actually ever really in your proper person, that every act that you do is preceded by an administrative process, meaning you're an official capacity every time you do something. So when you go out and you enter into a contract and you're identifying as a taxpayer, because you are identifying yourself as a taxpayer because you're using a legal name. And then you go and it's time to sign the contract and you just sign your personal name. Wouldn't that be an error? Wouldn't that be an error? Just think about it. If I'm acting as RoboCop, and RoboCop is the principle that I'm acting under, RoboCop, that's my principal identity. Okay, I'm gonna make it plain for you because you don't understand commerce. So I'm operating as RoboCop. When I go enter into a contract, I sign Isaiah Bay, but I'm acting as RoboCop. Do you get what I'm saying? I'm acting as RoboCop, but when I go sign the contract, I sign mine. I don't even mention that RoboCop is even involved. Now I'm supposed to be acting as RoboCop, but every time I go enter into a contract, I'm acting as my personal self, rather than recognizing RoboCop is involved with me. So if you're acting as a taxpayer and the Social Security Administration says that a legal name is used to sign contracts for administrative and legal purposes, why are you not signing your legal name? Why you keep signing your name personally on the contract? If you're using a legal name, don't you supposed to sign that name to the contract? Ain't that the name that you're authorized to use? So why are you not using it? Explain that to me. Why every time you sign a mortgage, a lease, a license, or any contract, and you're acting through a taxpayer, why are you not signing as the taxpayer? Because that's who you're acting as. You're not signing, letting people know you're acting as this person. You keep acting like it's just you by yourself. And then you wonder why you got to pay all the debts, why you got to be liable for everything, because they don't know of a legal capacity because nobody's signing in a legal capacity. If you're not signing legally in the capacity that you have the rights to act under, you just signing your name, no wonder you in debt. No wonder you in debt. Because you don't understand what a legal capacity represents. Let me explain something to you. If you really understood what I was talking about, it would change everything. You know why? Because the Constitution says that you are protected in your person and in your papers. Let's look this up. Let's Google this. Legal definition. Let me show you. Protection in persons. All right. Now, you probably would never Google that because in your mind, you wouldn't think that it would be a legal definition for protection in persons. But we're going to see if there's something in it, right? I learned that it's a definition for damn near everything you can think of. Any phrase you can think of got a definition. You just got to learn how to research, okay? So in legal terms, a protected person is an individual who is afforded a special legal safeguard due to their vulnerability. Okay. Now you got to read between those lines. Okay. I want you to Google this. Please go to Google and Google the legal definition of protection in persons. Google that. Google it, please. Just do it right now so you can get an understanding of what's going on. Because the Constitution said you are protected in your person. So I'm trying to help you understand what that means, right? Because you don't understand what it means, because if you did, you wouldn't keep trying to separate yourself from your person. You wouldn't keep trying to be an agent or separate. You see what I'm saying? They didn't wonder why they beat you up. Bow, bow, beat, boom, bow. You know what I'm saying? You don't understand commerce. You see? And brother trying to tell you, the Constitution even tell you, you're protected in your person. So that means you have to be in that capacity to have protections. Meaning, if you're operating outside of your legal capacity, then damn, you out there on the ledge. You floating without a safe jacket. What? You know what I'm saying? You better get it together. You better understand what I'm trying to show you on the screen. Okay. Now, in legal terms, a protected person is an individual who is afforded special legal safeguard due to their vulnerability. This designation is often applied to minors or individuals deemed incapacitated, right? For whom a court has appointed a conservator to manage their affairs, right? Protected persons may also include those under a protective order issued by a court, ensuring their safety from harm, exploitation. A legal framework aids to prevent abuse and provide recourse when the individual cannot adequately protect themselves, right? So remember when I say that commerce is a war against persons. So what they did is they gave every man and woman a legal person legally to identify in the system through. But the person is your property. It's also protection for you. All right. Your person is your protection, but you're only protected in the person is when you're in your person, meaning when you're acting as a taxpayer. That's where your protections come from. When you're acting outside of being the taxpayer, you don't have any protections. Your protections come like when you go to court and they call out your legal name and they say Isaiah Joaquin Bay. And I say, yes, let the record reflect that I'm the living man, Isaiah Joaquin Bay, acting as the defendant in my legal capacity. That automatically grants me protections right there because they know I'm a man, but they also know that I'm acting as the defendant in a legal capacity, which now they can't forcibly make me personally liable because I'm expressing the trust. I'm expressing who I am and what capacity I hold in reference to the record being charged. Okay, that's very powerful. Whether you understand what I just said to you or not, it's very, very powerful. If you understand that being a taxpayer is no different than being a prosecutor. Being a taxpayer is no different than being a judge. Being a taxpayer is no different than being a CEO, or being a taxpayer is no different than being a bailiff in your legal capacity. When you go in that courtroom, everybody standing in that courtroom has a capacity legally that they're acting in. And as long as they're doing what's required under that capacity, they are exempt from charges, fines, fees, because they're doing an official act within their official authority. You, as a taxpayer, have that same capacity. You have the rights to appear as the taxpayer in the legal capacity, representing your rights under the agreement. You got the rights to appear in your legal capacity. You got the rights to identify who you are and then let the court know that you're acting in the legal capacity as the defendant. They can't tell you that you're not, it's on him to prove that what you're saying is not true. He got to prove that you are that person rather than a person acting under that identity. See, and you got to be the one to substantiate that with the prosecuting attorneys and things like that. When you go into court, a lot of us is running from the taxpayer. We keep saying, oh, no, they trying to make me a debtor. I'm the agent. I'm the representative. But what I'm trying to get you to see is to act and to let others know who the actor is. That's where your protections come from. All right, is when you're able to express capacity, when you're able to show capacity. When a man comes forward and claiming that the defendant is his legal capacity, that he's acting in that capacity as the defendant. Now, when you come, that's where a proof of claim comes in now. Because if I'm acting in a legal capacity, and in that legal capacity that I'm acting in, I've been charged, right? Then that will make me have to make a proof of claim, right? But because I don't want to be charged in the legal capacity that I'm acting in without them understanding who the true actor is. So if they're charging me in my legal capacity, then I have to substantiate certain things. Certain claims have to be made in order to substantiate the record to recognize the real person of interest, which will be me. I'm the real person of interest. But I'm acting through my legal identity. So legally, it can be assumed and presumed that the legal identity, the person I'm using, is actually me without them substantiating that person's real identity. Everything we deal with is about substantiation of the person's identity. When you enter into a contract and you get approved for goods, all right, those goods are approved for a specific person, but they are charged to a principal account to pay that person. Being that the account and the man have similar names, the man can get caught up in the mixture of everything. You know, not understanding that when I say your person is your protector, if you get approved for a lease, your account is required to provide rents as credits to the lender, meaning that when you're acting as the taxpayer and you sign in the right capacity an agreement for the taxpayer and in your right capacity, then you have the rights, right? Once you have accepted those goods in your legal capacity, you have the rights to pay those goods. Also, as the legal person or the principal responsible for those payments. Okay, now nobody should ever enter into an agreement and then allow the lender to collect the approved balance from you. If you enter into an agreement and there's an approval of an balance, you should make sure that the lender provides that balance, and you need to make sure that it's applied. Before you pay the lender, you got to make sure that he provides the approved balance. Every contract that you enter, there will always be an approval first because the value has to be approved that you can use. Remember, we don't have money. We don't have no real value. So whenever you enter into a contract, the signature creates the value. The approval of the value is what generates the source of the fund. All right. So the funds come from the approved balance. So now I'm gonna look up something. I'm gonna let y'all know where I'm at here in a second. All right, so where I'm at 18 USC. I'm gonna give y'all a chance to catch up. All right, so I'm at 18 USC. 891, subsection 891. So 18 USC, subsection 891. I'm gonna give you a chance to get there so you can read along with me. Okay. Give you a chance to get there. Let me make sure, because they got so 18 USC 890. Okay, so I'm gonna read it. Now, this right here is called extortion credit transactions. So, as you know, the government don't have money, so all they can offer is a right of credit. If you go and apply for something and you get approved, you're getting approved for credit. Credit is the rights to enter into a contract and receive a due balance as part of your credit agreement. If they make you pay the due balance by giving them cash to pay the due balance, that means that they've extorted you because the due balance was what they loaned to you. When you received that loan agreement, it was disclosed. The payment schedule was disclosed to you. It told you the due dates, the amounts. That's part of your loan. That's part of your purchase. So if you gave it back to them, how are they collecting that? They should be applying that because it's already been purchased by you. When you sign that agreement, you purchase every due balance as part of your purchase. And when you gave it to them, instead of them trying to collect them as if it's something you still owe, they're supposed to acknowledge that you already purchased it. When you signed it, you already purchased it, and now apply it. They're not applying it though. They're trying to collect it as if you still owe it rather than you've already tendered it to them as part of your tender. All right. Remember, when you accept the contract, you're not just accepting the instrument. If you give me a lease and it got due rents in it and I sign it, you can't just acknowledge the lease as the only value that you're receiving and then try to collect the due rents later as if you didn't receive those rents along with the lease at the time when I gave it to you. You received both of them. So for them to take the lease from you that's stating what the rents are and only accept the lease as value and don't acknowledge that the rents were stated in the lease as value too, and only give you one side of the contract as value and say, well, you owe us this other side. How do I owe you anything when I provided you the principal note with the due balances in it? I gave you everything at the beginning, but you didn't apply it. You withheld my due balances and then start trying to collect them rather than acknowledging that I have a right to have those amounts applied as part of my agreement. Okay, let me hold up. They trying to cut me off. Hold up, y'all. Hold up. Something happened to my charge. All right, I'm back, man. So now we're gonna get down to the nitty gritty, man, because you got to understand when you're being extorted. Okay, when credit is the rights to receive a loan, right? And when you get approved for credit and you receive a loan, then you shouldn't have to pay anything. The credit that you was approved for should actually settle your obligation. And the one providing you with that approval is the one to make sure that the credit you are approved for is actually being provided by him. If somebody was to approve you for a $50,000 loan and they never provided the 50,000 once you got approved, and then you end up having to pay the whole $50,000 30 days later in installments, that means you got extorted because you got approved for 50,000. And if the lender would have provided that 50,000 that was approved for the car would have been paid off. The title you'd have had the title and everything because the lender paid it off by applying the approved balance. If you got approved and signed the contract and then he made you pay it, he extorted you. He made you pay his obligation because he's the lender. And the lender is the one who should be providing the loan balance, not the consumer. The consumer is the one who's borrowing, receiving the loan balance from the lender as part of the purchase. So if it's in reverse, that means something you got extorted. It's in reverse. It's opposite. They taught us the opposite way of understanding contracts and made it acceptable by us. So we operate in default and we accept it and don't understand that it's incorrect. That you're not supposed to pay the lender. The lender's supposed to pay your contract because he's the one lending the credits. Okay, you don't have any credit. You don't have any credit. Everybody keeps saying you gave credit. No, the lender is the one who gives credit. You gave value, meaning you accepted the rights to receive credit from the lender. Okay, he's the one that's responsible because they're the ones giving us loans as currency, and currency is not actually the value. The value is the amount stated in the currency. That's the loan that the lender has to provide. When he gives you the instrument is evidence of his indebtedness to you. So the instrument holds your rights against the lender. Like if you got a lease, that's holding your rights against your landlord for rent. You got a rights to demand rents as part of your approved balance that you didn't receive. If you holding the lease and your landlord collecting the rents from you, you need to dispute that and you need to redeem that lease and demand he pay you rents because he offered that to you as an extension of credit. And you should be using those rents in that instrument as part of that credit that he offered instead of paying them to him. That's crazy as hell to pay credit that you are entitled to. You know what I'm saying? That's crazy. These people taught us like this, man, and got us living upside down like this, man. Check it out. It says the purpose of this chapter, right? It says to extend credit means to make or renew any loan or enter into any agreement, tacit or express, whereby repayment or satisfaction of a debt or a claim, whether acknowledged or disputed, valid or invalid, and however arising, may or will be deferred. So whenever a debt is created, it should be deferred automatically. It will be deferred, right? The term creditor with reference to any given extension of credit refers to any person making that extension of credit or any person claiming by under or through any person making that extension of credit. So it's telling you that the creditor is the one who extends the credit, or it could be the person who claims a right under the credit that has been extended. So either party is acting as a creditor. Now, the term debtor, with reference to any given extension of credit, refers to the person to whom that extension of credit is made, or to any person who guarantees the repayment of that extension of credit, or in any manner undertakes to indemnify the creditor against loss resulting from the failure of any person to whom the extension of credit is made to repay the same. So when you sign a contract, you're acting for the legal account that the creditor is issuing the credits for. As the underwriter for your own account, you have to make sure that your account principal repays the same value that's extended. So by paying it to the order of the lender extends it to the account, and then you pay it to the order of the lender, right? So that the account's obligation is paid to the lender, right? Now it says, the repayment of any extension of credit includes the repayment, satisfaction, or discharge in whole or in part of any debt or claim, acknowledged or disputed, valid or invalid, resulting from or in connection with the extension of credit. So credit should be returned, disputed, or discharged. That's what it's saying. You should not be paying for credit. If you got approved for credit and they got you in debt where you're paying money to them for credit, you got to pay for credit that was approved. That you should be disputing. You should be claiming a right to have that amount applied. You should be demanding and claiming that those due balances are credits. See, your thing is you're not disputing. You're accepting what they're offering to you as if you owe it, rather than you have a right to collect it and apply it. To collect an extension of credit means to induce. Now listen to this. It says to collect an extension of credit means to induce in any way any person to make repayment thereof. So to repay, to collect is to induce. So when they induce you, or when they collect credit, right, that's been approved for a man or a woman to use for his personal use, instead of them applying it so you can use it, when they make you pay the same amounts that you were approved for, that's considered as extortion, because they're inducing you. And to induce somebody is to make them believe that they owe something that they don't actually owe. You were approved for credit, but they're trying to make you think that credit is a debt that you have to pay out your pocket, rather than an amount that you have to acknowledge and demand be applied. You see what I'm saying? So anytime somebody induces you, billing you, making you think you owe them credit to pay them for credit, that's extortion. Because credit, you don't have to pay somebody for credit. You just make sure that the credits are assigned to them so that they can apply. Okay? But instead of telling you, hey, just assign this to us so we can apply it for you, they're collecting it like if you owe it. No. The repayment, now it says to collect an extension of credit means to induce in any way any person to make payment thereof. An extension extension of credit is any extension of credit with respects to which it is the understanding of the creditor and the debtor at the time it is made that delaying in making repayment or failure to make repayment could result in the use of violence or other criminal means to cause harm to the person, reputation, or property of another person. The term state includes the District of Columbia, so it's letting you know the person that's doing this to you is not America. It's the District of Columbia. It's the representative state that you're doing business with, right? Now it says organized crime is interstate and international in charter. Its activities involve many billions of dollars each year. It is directly responsible for murder, willful injuries to persons and property, corruption of officials, and terrorism of countless citizens. A substantial part of income of an organized crime is generated by extortion credit transactions. So a lot of these companies, they make income off extorting consumers and taking the income that consumers are approved for, making the consumer pay that income to them directly so that they can reap the benefits rather than the consumer who the income was approved for. Now, let me explain this to you. When you sign a debt, right? Understand this. If you go and you sign a lease, the rent is considered the income. All right. The principal is the lease itself. The income is the rent, meaning that should income back to the lease. Income comes back into the lease. So whenever you get approved for a loan, it would always give you a schedule of the income to be applied to. All right. So income is income in value generating from an asset that should be paid back into the asset. Because in accounting, if the value generated from the lease, then the value that's paid has to be paid back into the lease. You got to use the same value that the lease generated. So if the lease generated rents, you can only pay the rents that generated from the lease. You can't go to your job and pay rents from your job. You're not paying the lease off when you do that. You can't go to your brother and get a loan and then go try to pay your lease off. That's not paying off the lease. That's offsetting the lease. Because if you really paid the lease already got its own value. Why are you not using that value that the lease generates to apply to the lease? If a mortgage is a financial document that generates value, why are you not assessing the value of the mortgage and using it? Why are you trying to go to work and pay the mortgage? If you got approved for an installment loan contract from a dealer and it's been approved, then that means that the value of that instrument is already available for you to use it. You don't have to go to work to pay off your installment. You don't have to do that. You don't have to do that. All you have to do is accept the terms and agree to the terms. And then for the consideration, in exchange for what they gave you, you give them something that's equal to what they gave you in consideration. It's a swap exchange. You give me an item, I give you a negotiable instrument. You give me a lease, I give you a promissory note or a negotiable order to pay. It is what it is. What am I paying? I'm paying the amount you gave me back to you. But I'm not paying you out my goddamn pocket. You gotta be out your damn mind. If you give me a lease, I'm gonna draw an order against that lease and pay the rents from the lease to you. I'm not giving you money out my pocket when the lease gives me rents and gives me the right to draw an order to pay you those rents. I'm gonna create a negotiable instrument for rents because the lease gives me the rights to issue an order of rents. We live in a system that money equivalent is negotiable instrument. So if I got approved for rent, I can create a money equivalent. Tell me I'm lying. Put your money where your mouth is if you think that what I just said is far-fetched. All right? That's how the system works. All right? They give you an instrument and you give them an instrument. That's how it goes. It's a swap exchange. See what I'm saying? Instrument for instrument. When a lender receives your contract, he should also receive the due balances as a negotiable instrument with that contract. You should never give a lender a contract without a negotiable instrument for the due balances. Every contract should have a negotiable instrument attached to it paying due balances to the lender. Every one of them. If you're not doing that, you're not paying your contracts. Okay, let's get that together, right? So I'm gonna stop right here, but I ain't gonna go too much into this extortion about credit, right? So let me explain to you why it would be extortion. If you came to me and you applied for a loan, say it was a personal loan for $50,000, my institution approved. So what that means now with me is that my books show that I owe you $50,000 because you got approved for a $50,000 credit in my company. Okay. So now we draw up a payment order with a repayment schedule. Now you might be unaware that you already got a $50,000 credit because it's been approved already. That you already got a credit of $50,000. Now I'm about to give you the debt. The debt represents you paying that $50,000 back to me. All right. And it's being disclosed to you how much you were approved for, everything. Now, when I give you the instrument, in your mind, you think you got to pay me back 30 days later. But nah, when I give you the instrument, I'm giving you the instrument so that you can know the terms and the amounts and the dates of the amounts that you've been approved for. So every due balance that you see on that instrument is a credit with me. Those are your credits. Every due balance is the credits that you have with me for the approved balance that I approved you for. But in your mind, you might not look at those due balances as credits. You might look at those as debts that you owe 30 days later. But that's not what that is. That's not what that is. When you get approved for a loan and they extend the instrument to you and you see the APR, the financed amount, that's the amount that the lender owes you. That's the amount that you have a right to have that reduced. Instead of you paying him, you should be demanding and accepting that balance and demanding that it be applied to reduce the debt, because you shouldn't have to pay with any other value if you've been approved for credit. So if you've been approved for credit and you got the instrument evidencing how much credit needs to be applied towards it, then you should be giving an order to the lender to apply the credit by letting them know you accept the terms and you agree to everything and you agree to use the amounts that were approved. And as consideration, all due balances under this agreement are payable to your order. As the holder of this note, I transfer all my rights under this note to you in order that you may consummate the loan and process the due balances as approved by me, the buyer. So now I'm telling you, instead of me giving you the instrument back and the due balances is still due and you thinking you're going to collect them, no, you ain't finna collect shit. I'm finna give you an order to apply those balances because they already been approved for me. Why would I allow you to collect them rather than tell you how to apply them when they've been approved? See, we crazy. We crazy as hell. We get approved for a loan and they tell us how much we approved for and we just give them back the instrument. Don't tell them how to apply the amounts or nothing. You reading it, it's saying your first payment is $250 on January the 1st. You ain't gonna tell them how to apply that. You ain't gonna get no orders. You just gonna get an instrument. And then you wonder why he started trying to collect from you 30 days later because you didn't give any instructions. So in his mind, all he got is your signature and your promise to pay. See? But I just wanted to say that, man. Like credit is the rights to receive an instrument and then use the due balances in the instrument to settle the instrument. Let me say it again. Credit is the rights to receive a negotiable instrument such as a lease, a license, a mortgage, a rental agreement, and then accept every due balance that instrument is saying is due to be paid. You got to accept that balance and agree to the terms. Why are you accepting the balance and agreeing to the terms? Because the balance is the loan. That's the balance that you're receiving. The reason why you accepting the terms, because the terms of that balance is credit. It's credit. So when you accept and agree to the terms, you're accepting the rights to use credit. That's why you say, I hereby accept and agree to all terms. Why? Because the terms are credit terms. So if you want to use credit, you accept it first, agree to its terms, and then you provide an order on how you want those credits applied. You don't actually go to work and work 40 hours a week just to get $70 just to pay one monthly payment. That don't make sense. Don't make sense when you've already been approved for credit. Did you know that proceeds are the amounts generated from an asset? Did you know that assets generate what's called proceeds? What are proceeds? Proceeds are dividends that are issued from an asset to a person entitled to the dividend. So every month when you get a bill, that's considered as a proceed. That bill is generating from the asset you created with that company. And every month that asset is supposed to provide a dividend for your services. So every month your account generates a bill and then the lender issues that bill to you. That's considered as a proceed. Proceeds are cash like payments that can be deposited in checking and savings account. Proceeds acts as cash. So when you receive a monthly bill, you're receiving something equivalent to cash that can be deposited into your checkings or your savings account as proceeds of a third party that approved you for money, right? So since you've been approved for a loan, every month you get an amount from that loan that was approved. It comes as a debt, but credit comes in the form of an obligation. That's how credit come. All credit comes like. So once you start understanding what proceeds are, and that proceeds are payable like cash payments that can be converted into cash within a short period of time. So a bill is something that's convertible into cash, meaning that it can be endorsed and deposited into a checking or a savings account and then produce cash like funds. All all it has to do is be due to you and accepted and tendered by you uh, in order for it to be accepted as a negotiable instrument. The bank, your bank account is a deposit account agreement. When you receive value from a lender, you're supposed to accept the value and then make a deposit for the value into your checking or savings account. All right. The bank is there for you to make negotiable transfers. You receiving negotiable instruments, or you receiving instruments that you can convert and make into a negotiable instrument that could be deposited into your bank. All right. So you got to understand that everything that you're receiving is negotiable if you know how to convert it. You can make it into something that's equivalent to cash, and then you can use that same item to deposit it into your account. Okay, that's how negotiable instruments work. Okay, they are convertible instruments that can be converted into cash, right, within a short period of time. Like, so just keep that in mind, and remember that extortion is anytime you get approved for credit and the same amount you approve for, they end up collecting it from you. Just think about it like this. Whenever you get approved for a loan, then that person that's approving you is the one that should be paying the loan for you. If I approve you for 50,000 and then I collect 50,000 from you, how did you get a loan from me? When did you actually get the loan? I mean, you got approved for 50,000, but 50,000 was never provided. Instead, 50,000 was being collected. After it was approved, I made it seem like you got 50,000 and you never gave it to me. Now I get to collect it back from you because you got approved for 50,000 and now you owe me 50,000. But how is that feasible? How do I owe you 50,000 if you never applied the $50,000 balance to me? If you approve me for 50,000, but I never received it or it never got applied, and then 30 days later you're demanding to collect 50,000, but you are the one that approved it. You are the one that said I was good for it. So when did you give it to me? Once you give it to me, then I'll pay it back to you. All right. Now, if you're giving it to me in a deceptive way where I don't understand it, I've already received it, and because I didn't understand that I did receive money from you, and I didn't understand that it was money, I default. So I gave the money back to you without paying the balance of that money that I was supposed to pay. So a lease is money. It is money. It's a negotiable instrument, right? But it has to be paid when delivered. Meaning if you deliver that instrument without paying it, then whoever accepts it can collect from the person who delivered it, because that means you still owe payment on it because you didn't pay it. You delivered it, but you didn't pay it. So if I accept it and it's been issued by you, so you can even issue to my brother. You can issue it to my brother. But if it was issued by you and it was not paid, and then you issue it to me, and I accept your blank endorsement, and I make it payable to somebody else for collection and payment. Now, what am I telling them? I'm saying this is assigned to you to collect the payment from the signer. That's basically what I'm saying, because the original signer is the one on the hook. If you signed it, right, and you gave it to him, and then he signed over your name and paid it to somebody else, the other person, now the instrument is payable to him. So if these amounts are now due to me, I can collect these amounts. Who's the one responsible to pay these amounts to me? They're going to look at the signature. When they look at the signature on there and they see just your signature, then they see somebody assigned it over you to them, then they get to go after you. They say, oh, so he's the issuer. He's the one that's promising to pay these amounts. So now that it's been assigned to me, I'm going to collect these from him. So they start billing you. That's how the bank with the dealer end up billing you for the amounts, because the dealer transfers it to the bank. Once he transfers it to the bank accepts that assignment from the dealer, and then the bank looks to see who's going to repay the loan. And since the dealer is the one assigning it, the bank looks to the signature of the signer as the one promising to pay. So now the bank comes after you. They're coming after you for payment because your signature was on there, and at the time when the instrument was assigned for payment, right, it was payable against your signature. So like what I'm telling you is when you issue a negotiable instrument, right, you got to make sure that the instrument is payable to a specified person at the time of issue, all right? Because if you don't make it payable to a specified person, then the other person who receives it can make it payable to another person. And since your signature is signed on it, then you would have to pay that other person because you signed it. So since you signed it and he assigned it, now you got to pay it. But if you make it payable to another person, then that means that whoever gave it to you got to pay that other person when they collect it. So let me give you an example. I give you a $50,000 loan, right? If you accept the loan and then assign it to another company, you say, I hereby assign all my rights, titles under this loan agreement to the order of Ford Motor Company. Ford Motor Company should have the rights to receive this agreement, act as me as the owner, and collect every balance due to me under this loan. Now, once I sign that and I send it to Ford Motor Company, giving them the rights to step in my shoes and collect the balance due to me from the lender is on the hook. He can't get off the hook because he's still under the assignment. Only way the lender gets off the hook is if I accept his liability. Meaning if he assigned an instrument to me and I hold his liability, then I'm agreeing to pay his liability because I'm holding it. Now, if he's assigning it to me, due balances that he's saying is due to me, and I want to use those balances, it's better for me to use those balances is by assigning them to somebody else to collect them for me. See, if he approved me for $50,000 and he gave me an instrument saying these amounts are due, and I got the dates and everything, and I want to receive those balances that are due, right? I'm gonna assign that to a bank. I'm gonna say, I hereby accept and acknowledge this, agree to all the terms as consideration for the value received. I hereby assign my rights to Bank of America, my paying agent. I give my paying agent the rights to receive this contract, act as me, and collect every due balance approved by the lender. Now, what am I telling the bank? I'm saying I've been approved for an amount. I'm giving it to you. I'm assigning my rights to you under this approval amount that I just got approved for. And I'm giving you the rights to act in my place to collect every due balance that the lender is responsible to provide as part of the approved balance for my loan. If I don't do that, and I keep that loan without assigning it to somebody else to collect what the lender owes me, then the lender can collect it from me because I didn't assign it to get collected. You got to assign your rights or you got to perform. You can't just hold a contract. If you hold a contract, then you're agreeing that you agree to pay the lender because the lender is on the hook. He's the lender. He has to be the one to provide the amount. He can only provide the amounts when you do an assignment for those amounts to be paid. If you don't assign the contract, if you don't perform under the contract for the due balances that you're holding, then once that, so you got to remember, either you can make it payable and assign it to somebody else so that they can receive payment of the obligation the lender promised you, or you can just hold it. And then on the due date, it becomes payable against you. So now the same right that you had to receive those payments, because you kept the instrument in your possession and 9/10 of the law is possession, and then the instrument became payable, guess who got to pay now? It's payable in your possession, not nobody else's possession. It's payable to you now because you held it all the way up into the due date. And then on that due date, it became payable. And because you had possession, guess who got to pay? You do, because you held it all the way up into the payday. See what I'm saying? If you really wanted the lender to provide you credit, you would have assigned that to somebody else for collection and payment. You would have treated the bank like a debt collector to collect the debt the lender owed you. You would have treated the treasury like a debt collector and assigned the mortgage to the treasury for the treasury to collect the amount the mortgage company owes you. Does that make sense? You got to change your perspective, man. You got the wrong concepts. And if you don't change the way you think, you won't change your life. Change the way you think, and you can change your life. And that's for certain. Remember, the lender is the debtor. He only gets off the hook if you don't assign his obligation for collection, meaning that he's the obligor, he's the promiser in the very beginning. He's the one promising the amounts that are due, but he can get off the hook if those amounts are not assigned to be collected against him. If you don't assign the amounts, then it could be assumed and hold up, y'all. Okay, now come on now. All right. All right, so I'm gonna say this, man, and y'all need to be tapping the screen. I only got 6'5". Y'all with the type of knowledge I just been giving out, man. No way I only got 6'5". Y'all playing. I'm about to cut this live off because y'all don't show love the same way I show love, and that ain't consideration, okay? Because I could be telling you to give me some money for this. I could be telling you, hey, I need this, and you need to sign up. You know, I'm giving you information, and I'm teaching you for free. I'm not charging you a dime. I'm charging you is to tap the screen and share out the live. If you can't do that, then you don't deserve consideration. You know, then that means that you're being selfish towards everybody else that's on here that's giving consideration, that want to get the information. In no way you can. Name one thing, it's another. Like one thing keep happening, another. All right. So like I was saying though, right? So when it comes to contracts and agreements, remember the lender is the debtor. The reason why the lender is considered to be the debtor is because he's the promiser. In order for him to loan you something, he has to promise. If I'm lending something to you, I'm promising that I'm gonna give this to you. Okay. So if you apply for a loan and I say it's approved, then I'm promising to provide the amounts that you have been approved for. All right. So now how does this work? When you apply for a loan, you're not applying to the lender. You're applying to the state government or the United States for an approved balance. of credit because the government is the finance. All credit has to be financed by the United States, and all debts have to be charged against the United States because the United States is the debtor. Okay, so when you apply for a loan, the lender, right, is acting for the principal. The principal is the United States government. Okay, he's an agent of the principal, acting on the principal's behalf to service the people. Okay, so when you get approved for a loan, it is the United States government approving that loan because they are the finance. The lender who provides you with the currency is giving you the currency, but the due balances that is disclosed to you, that's coming from the government. That's not coming from the lender. That's coming from the actual creditor, which is the government. The government is the creditor. So financing is the due balance. The principal is the instrument that you receive from the company. That's the principal loan. But the due balances that you have to pay, that's the financing that the government is responsible for. So when you receive a loan, you're receiving two balances. The principal instrument, that's the loan from the lender, and then the due balances stated in that instrument is the loan from the government. So you're receiving two values. You're receiving principal and interest stated as a repayment. So interest is always scheduled to be repaid back to the note. But in our mind, we look at those payments as amounts we supposed to pay the note off. No, those amounts are already there and available to be applied back into the note. You just got to give instructions to the lender and identify yourself as the purchaser of those balances, and then give instructions on how you want them applied. All right. Rather than going to work to pay those balances, why would I go to work to pay a balance that the instrument already gave? It's already been approved. I already got the instrument. I already got approval for the value. You don't have to go to work to pay value in the instrument. If I got a lease in my hand and it got scheduled rents, all I got to do is enforce the lease. Acknowledge that I'm the holder of the lease, has been approved for me, and that I accept this lease, redeem this lease, and claim my rents. And as the holder of this lease, I assign my rights to the rents claimed under this lease to my landlord. Why? Because you owe me goddamn rents, boy. You owe me rents. You the one promised these rents in this lease to me. And then thinking I'm going to pay them to you rather than assert my right to have credit of the amounts you approve. Why would I pay you the rents instead of claiming that the rents be credited as part of the approval that you gave me? When you gave me the lease, it came with rents. Rents was already scheduled. So that means that they were a part of the purchase. So why am I paying you rents rather than demanding that the rents that came with the lease be applied? Your lease came with rents, man. It came with rents, scheduled, due dates. How the hell did you end up thinking you're supposed to pay that out your pocket rather than acknowledging it as rents received with a lease? You already got rents. They came with the lease. Am I lying or I can't be making this up, man. You can't tell me that your lease didn't come with rent. Show me one lease that don't have stated rents in it. Show it to me. All you gurus, all you smart people, show it to me. Since you're qualified to teach the people, show me one lease that doesn't come with rents. You can't. You can't. Because they all come with rents. They all come with rents. You can't show me one lease that don't state rents that are due. You just got the wrong concept. You think due rents mean you got to pay them out your pocket. You don't understand what due rents mean when you purchase an agreement. You don't know what the word amount due means when you're purchasing products. Let's look up the legal definition of amount due. See, I'm a scholar. You know, brother, I say I'm a scholar. You hear me? I ain't like the rest of it. Let's look up the legal definition of amount due. Please, somebody help. Because I'm trying to understand why you broke and why you struggling when everything is set up for your benefit. All right. See, see, another thing is a lot of y'all Y'all think y'all already know what this stuff means. You crazy. You think you know what the word you mean. Y-O-U. Have you ever looked up the legal definition of the word you? Have you looked up the legal definition of the word we? Have you ever looked up the legal definition of the word I, self, individual? Or you just assume you already know what these words mean? Well, you'd be surprised what stuff means, boy, when you look it up. You'd be like, whoa, I ain't know that meant that. So the whole time you had the wrong concept. You was miseducated purposely. So you wouldn't understand it. So you only deal with words on common levels, and you'll never look to the legal aspects of what words mean. Because legally they mean something different than they do normally. Okay, so when you look up the definition of amount due, it says the total sum that is owed or payable. Now, why would it say owed or payable? Isn't the word or a conjunction? All right, let's look up we're gonna look up the legal definition of or. See, because I don't believe in assume. What is the legal definition of or, right? So or, the legal definition of or. The legal definition of or refers to its use in legal documents and statutes, where it typically indicates an alternative or a choice between options. Okay? For example, in a will stating, I leave my property to my niece Sarah or my nephew Ben, it applies that either Sarah or Ben can inherit the property, but not both. The term can significantly affect the interpretation of legal text, as it can create ambiguity regarding the intent of the parties involved. So let's go back. So when you look up the word amount due, it says the total sums that is owed or payable. So what it's saying is the word or is giving you a choice. Either you owe that amount or it's a payable amount you can pay. It's one or the other. You got to figure it out for yourself, okay? Because everything has two sides to it, right? So either you owe it or it's something that's payable by you, all right? In legal terms, amount due refers to the total sums that is owed or payable, often associated with debts or contractual obligations. It indicates the specific sums, right, that must be paid at a designated time, right? Such as a due date. For example, in contracts, the amount due is the principal sum that must be fulfilled by the contract party. Additionally, amount due can also refer to financial assessment penalty, right? Or any financial obligation to be addressed. Understanding this term is essential for anyone dealing in financial agreement or legal documents. So amount due deals with the total sums, owed and payable, both sides of the ledger. Not one side, but both sides. Okay? Let me show you something. So amount due. Now I'm gonna look up, show you something. Now I'm gonna look up, and I want you to do the exact same thing. All right, because I want you to understand. And y'all make sure y'all share, hype me up now. Share the live out because I'm giving out very powerful, very good information. And you should want people to have this. You should want to share this information, especially if I'm giving it out like this, and I'm breaking down things to help you understand and give you an insight. And you should want other people to want this knowledge. And you should want to help me reach more people, because if I'm doing a great service for the people, man. So all I ask is that y'all help me reach more, help me get out there so I can get to the right people. Because if I get to the right people, I can make some changes based off some things I know. All right, now check this out. Now we're gonna look up legally When something is due, is it also payable? Or I want you to look up, is due and payable interchangeable phrases? Okay. So I looked up on Google, when something is due, is it also payable? All right. So I Googled that phrase, right? Now, this is what it says. In general, when something is due, it means that it is owed or required to be paid. However, not all obligations that are due are necessarily payable. For example, if an invoice is marked as due and payable, it indicates that the payment is due and must be made at a specific time. If an invoice is marked due upon receipt, it means that the payment must be made as soon as the invoice is received, right? But the customer may wait a few days to ensure satisfaction before making payment. It is important to note that due does not imply that the obligation is also payable unless specifically otherwise. But due and payable are interchangeable phrases. You know, usually when something is due, it's usually payable by the same person that is due to. So if it's due to me, then it should be payable by me because it's due for me to take the act or to do the act or whatever. All right. So now I say all that to say that, okay, your monthly invoices, bills are actually dividends, all right, uh that generate from the asset that they're holding. And those dividends are credits that can be applied to the account for the person utilizing the account. All right. When you open up an account with a lender, all you have to do is be over 18 years of age. And once they approve the contract, you got the rights to endorse the bill. All right. Because payment is made by endorsement, not by you going paying in cash or none of that. So if you already got a contract with a lender, he's already billing you payments already. That's a requirement. All contracts operate through a billing process or some type of process where an obligation has to be fulfilled. So anybody that's doing business with you 9 times out of 10, they already got an obligation to provide amounts to you, right? So every month you'll receive some kind of online statement, you'll receive a physical statement through the mail or something like that. In your mind, you think that that's a statement saying how much you owe. No, actually, that statement is actually value being issued to you for your usage. You're actually receiving that statement as an extension of credit. All right, they're extending credit to you through the form of a bill, through the form of a statement. You know what I'm saying? And you, as the man or the woman utilizing the account, know how to turn that statement into a contract in order to enter into a binding agreement with them. So if you don't know how to contract, every bill will become a debt to you because you still don't know how to contract. Contract is acceptance. Acceptance brings value. So when you learn how to contract, you'll learn how to accept value and use value for your benefit. If you don't know how to contract, then the bills become debts to you. Every month you'll be paying a bill because you still don't know how to accept and pay. All right. But every man and every woman has a right to accept and pay value, especially if it's been approved. If you've already been approved by a lender to enter into that contract, any rights you have, they are already available. You don't have to go and create some kind of document in order to express a right. If the lender felt like you needed a power of attorney to enter into a contract with him, he would have made you get one before y'all signed the agreement. He would have told you, hey, listen, you can't enter into this agreement unless you got a power of attorney. It got to be entered into by the proper person. He didn't ever say that to you. When you signed the contract, you had everything you needed in order to be the proper person for that agreement with the lender. Now, any rights you hold will be behind the information he already got. Why you got to go get another document? Why you got to go grab other stuff in order to substantiate your rights? Meaning you should be able to just take the document the lender gave you, and you should be able to take identifying information, identifying the name and the information in that document in order to substantiate any claims made by you. You don't have to go get 55 documents in order to show your authority. You don't have to do that. Your authority comes directly from the lender's promise, the instrument, and your ability to accept and assert rights. All right. You don't, as an individual, you don't need no power of attorney. Y'all need to stop doing that. An individual, you cannot use a power of attorney for an individual. I'm gonna say this, and I'm gonna say it this last time, right? An individual is a sole proprietorship, all right, where the entity and the owner share the same exact status. So even if you did a DBA, you can't do a power of attorney for a DBA. They don't consider that person separate from you. So if you did a DBA and then you go do a power of attorney saying you the agent for your company and it's a DBA, you incompetent. That right there, that'll show any other lender, any other creditor that you incompetent. You trying to do a DBA for an assumed name. Now, did you know that there's different types of agreements? Okay. When you're using a power of attorney is usually for a separate entity. It took me a while to figure this out too, because knowing the taxpayer is a entity and I'm a man and I'm not no entity, I'm trying to do a power of attorney for that legal name, and and instead of getting denied at banks and all this stuff, you got to learn, you got to go through mistakes, and then you have to educate yourself to figure out what you're doing wrong, because a lot of times you say that they wrong, but every bank, every institution can't be wrong about the power of attorney for an individual, because a lot of them say the same thing. So you have to go back and do your homework. So as an individual, you're not separate from the company. The company and you are one, just like you are acting as a taxpayer, and they treat you just like the taxpayer because y'all are one. All right. So when you register your legal name and do a DBA, all right, you can't issue a power of attorney for that company because they consider you and the company the same person, even though you're the owner, right? Now, what you can do, instead of trying to issue a power of attorney, you will issue what's known as an agency agreement. An agency agreement is an agreement provided by an agency authorized representative, an agent, or a personal representative, or somebody that's personally involved with the company to act in the agent's capacity, even though they're not separate from the agency. All right. So when you're dealing with a power of attorney, that's a separate document for a separate entity. So when you issue a power of attorney for your individual person, that's improper because you and your person are one. So being that you're operating individually, you can't use a document that deals with a separate individual. If you issue a power of attorney, then that means you're operating for a trust, you're operating for an LLC, you're operating for a partnership. I mean, it got to actually be a totally separate entity with its own number and everything with the power of attorney, right? Now, internal representation. That's what you need. You need to learn how to do internal representation for your company. So once you do a DBA or something like that, you don't need a power of attorney, but you do need internal authority. So that means that the company can issue an order for you. Just like once the company is created, the company is the principal. It's the highest authority. So if I'm an employee of the company or an agent of the company, and I have specific authority, specific duty, specific rights that need to be recognized in reference to this company and any other company, in reference to how we're doing business. Then the company, I would draw up an agency notice, and I would issue it from the office of my company with seal on it, saying that I'm being selected as an officer in the company. The company is giving me the power to act as agent, but it's not a separate power. Do you understand what I'm saying? I'm not separating myself, saying that I'm acting through a power of attorney like it's a different agency from me, when it's actually the same agency. I'm an internal officer. So as an internal officer, as what they call a inside, I'm an inside. I'm inside the company, not outside the company. I'm inside. So when you're dealing with authority inside the company, you're dealing with agency, where the agency, which is the institution that you work for or that you are hired for, issues an agreement pertaining to your relationship with that agency that can be provided to third parties in order to substantiate your position in the agency. You don't do a power of attorney. You do what's called an agency notice. Okay, I wanted to give you that because it's a lot of misinformation. It's a lot of people teaching stuff and still haven't studied enough to figure certain things out. You got people out here doing powers of attorney, still trying to open up a bank account in their personal name with a power of attorney, and the bank steady telling them, you and that's the same person. And they like, no, that's a legal entity. No, we are acting as legal entities. You can't get around it, man. You cannot change the fact that you are acting as a legal entity, and that you have capacity to do it. Why? Because you're a spirit. So you can act as an entity, because a spirit is an entity. That's why you're not the flesh, because the flesh is flesh. But man is not flesh. Man is spirit. Man is the power, the energy, the life, the force within that body that causes the body to move, walk. That's the man. The man is the power within. The body is just a vessel. As soon as that soul, that spirit leave that body, that vessel just laying there. It's just dead. So that wasn't the man, was not that. The man was that voice, that, that's the man. Okay, so you got to understand that you live inside a body. You live inside a body. You don't live in the earth. You live inside a body. You don't sleep in the bed. You sleep in your body. Don't you understand that? That you sleep inside this vessel. You don't sit on a chair. You sit in your vessel. Your vessel sits on the chair. I mean, it is what it is, because God said you're not the flesh. So if you're not the flesh, then what's sitting on the chair? And that's the reason why a lot of people are so upside down, is because people are, the spiritual awareness is low. A lot of people are not spiritually where they need to be able to discern truth. It's just like Christ, right? When they say Christ walked on water, a low-level vibrating person would only see that in a physical sense, which we know that that's not possible. No man can defy the laws of gravity. And God is not an author of confusion. So don't sit there and say, well, God said. No, God is not an author of confusion. He wouldn't tell us that Jesus can walk on water and never show us a man ever in life that's able to do it. You know what I'm saying? So that wouldn't logically make sense. That would be confusing for him to say that Jesus walked on water, and then Jesus make a statement to say that everything I've done, all men shall do, and even greater things. Not one man that I ever known can walk on water. Not one. Not physically. So that would mean to me, in my own understanding, is that if you listen to your pastor, you crazy as hell, because no man can walk on water. And Jesus said that everything he do, every man shall do, and even greater things. So if he walked on water and he said every man would do what he's doing, then that means that you have to change that perspective. Stop looking at Jesus walking on water in a physical sense and look at it in a spiritual sense. When a man spiritually is inclined with truth, he can walk all over water. What is water symbolic to? Commerce, commercial law, civil law. We call it the laws of the seas, the water. Ain't that what we dealing with right now? The laws of the sea on the land. That's what we say. They done brought Plymouth Rock on the land. They done brought the laws of the sea. The pirates that came onto the land. Ain't that what we saying? So when Jesus was walking on water, what was he doing? That means he was skilled in commerce. He was that's why he was flipping over tables on tax collectors. Why? Because why would they even tell you about him flipping over tables on? It's trying to get you to see that he was dealing with commerce. He was dealing with the exact same things that we dealing with now. He said we don't war with flesh and blood. He said we war with municipalities and wickedness and high places, something to that degree. I'm paraphrasing. But he did say, he let you know, well, I ain't warring against you, brother. You my brother. Man, look, I look like Oregon and trying to fight you when these people poisoning our food, poisoning our water. We ain't warring against each other. We warring against these big corporations. These corporations, these medical institutions, these pharmaceutical institutions, these child abortion centers. This is what we warn against. We warn against Snooks, Walgreens, Walmart. Everybody selling processed and fake food. When you go to each store, they got the exact same bull crap being sold in each store. All fake and processed food. That's what we warn against. We warn against the powers that be that allow fake processed food to be sold in all our communities. That's what we warn against. We're not warring against each other. We're warring against this evil that's become upon us. We're trying to figure out how to combat it, how to create organizations, how to come together and unify to create organizations to deal with that. Because we got to be competitive against what they're doing. They're using corporations and corporate policies to do evil, and we got to use the same to do righteousness. So that means you got to learn. You got to learn. If this is the order of the day, this is how they fighting and warring against us through silent weapons and wars, using commerce and water and food to kill us all. We got to come back. The way you deal with a serpent is by using the same venom to cure yourself. So if they're using commerce against us, how do we deal with them? We learn commerce and we use it against them. See what I'm saying? You gotta fight him with the same venom that he's using against you. In order to cure yourself, you gotta use the same poison that poison. And you gotta cure yourself with that same poison. So that's basically what's going on. You gotta learn that the system is designed a certain way to operate a certain way. And in order for you to be successful or benefit in this system, you gotta learn how it works. You gotta follow the rules, the regulations that are set out and designed for your benefit. Understanding that the system is not going to do everything right. They would go off. They would do things sideways just to make a profit. You know what I'm saying? At your expense. So just keep that in mind, man. Like I said, understanding your rights, understanding credit, understanding negotiable instruments, understanding agency, all these different things that I'm talking about are very important for your success. You got to learn these things in order for you to progress in the system. You got to learn negotiable instruments. You got to learn how to create orders. You got to learn how to utilize the documents, the instruments. You got to understand that accounts are not just accounts. Every account number holds funds. If you got an account number, that means you got available funds in that account. Every account, if you get an account number, it's not an empty account. Accounts hold value. If you got an account number, that means that you got value in that account. If you got a bank account, that means that there's value in the bank account. You might not be receiving the value from the account, but there's value in that account. Meaning all accounts hold value. Why do you think they give you an account number? Because all accounts hold funds. Why do you think they tell you not to give your account numbers out? When you file a UCC1, they say don't put no account numbers on there. Why? Because anybody that's competent can go in and access those funds. Anybody that know how accounts work and know how to use information, if you put your stuff out publicly, they can take your information and use it. They can receive the funds that you're not receiving because they understand things you don't understand. You think an account number is just a regular account number. You don't understand that all account numbers carry funds. If you got an account number, it's because you got a due balance in that account. And it might not be available right now, but I guarantee you at a later date, you're going to get a statement or some kind of bill from that account saying that a balance is due. Accounts are not empty. They carry balances. It's called money of account. Money of accounts. All accounts carry money. No such thing as an empty account. Factual. And then you wonder why they billing you every month because it's your account. If it's funds on account and it's your account, then that means you some way, somehow you can deliver those funds to them. You might not know, you might not understand, but I can guarantee you that if you got an account number and you were approved for that account, that the funds in that account are yours. Guarantee. And I guarantee you that every month the lender would notify you of how much funds is due in your account. In your mind, you just thinking it's a regular account. No, that's an account with funds. Every month, if it's credit and it's electricity, gas, or water, that's open-end credit. That means every month you will get credits. Every month the lender will provide you with balances. Every month until the day you die, because you have open-end credit, meaning you have a right to receive credit all the way into that account close. Now, in your mind, you might look at those same credits as debts, but you got to understand that credit is not a debt. Credit is a right granted and a right to be accepted and used. Most people end up in debt is because they don't understand the rights behind credit and failing to understand how credit works. Then, of course, you're not going to act. You're not going to do what's required in reference to the credits that's being provided. You know, you go to a dealership and you can read the contract. It says you can buy this contract on credit or you can buy it with cash. Most people don't understand what that means. They read this out. You can buy it with cash or on credit. They still don't know what that means. They end up buying it with cash. Why? Because they don't know how to buy it with credit. If you knew how to use credit and buy purchases with credit, you'll use credit. And you wouldn't end up having to pay out your pocket. The only reason why you're paying is because the credit that you have is not being used. If you use the credit, you wouldn't have a bill. You only got a bill is because the credit is not being used. And if the credit is not being used, then the lender gets to collect the credit because it's not being applied. So if you're holding the credits rather than applying the credits, then the lender can bill you for the amounts that you're holding. He already gave you the credits. You already signed the agreement. You already been approved for the balances. And you just holding the agreement. You just sitting there every month, just got the agreement sitting on the table. Every month they billing you and you paying them out your pocket. But you was approved for credit. You was approved for credit. All right, man. Let me give y'all one more thing before I go. All right, I'm in the Contract Act of 1872. I'll read something to y'all from the contract. All right, so we're gonna read. I'm gonna start right here. We're gonna start with acceptance. All right. All right, so it says that acceptance must be absolute in order to convert a proposal into a promise. The acceptance must be absolute and unqualified, right? Be expressed in some usual and unreasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If a proposal prescribes a manner in which it is to be accepted, and the acceptance is not made in such manner, the proposer may, within a reasonable time after acceptance is communicated to him, insist that the proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts. All right. So basically, what it's saying, an order. It says acceptance must be absolute, and then right after you read that, it says, in order to convert a proposal into a promise. We'll stop right there. So it's telling you that you got to modify, because it's saying in order to convert a proposal is anything proposed by the lender, whether it's a monthly bill, that's a proposal. He's proposing that as an amount due. All right. So it says in order to convert a proposal, right, into a promise, the acceptance must be absolute and unqualified. So it's saying that you have to take the instrument and you got to convert it from an order, a statement of account, right? You got to turn it into an acceptance, right? And it must be unqualified, meaning that it can't have no specific conditions to it. It just must be an absolute. I hereby accept and agree to the terms of this instrument. That's an absolute acceptance, okay? And then it says acceptance by performing conditions or receiving conditions. Performance of a condition of a proposal. So now it's saying, first it said that you got to convert it into a promise. To convert it into a promise, it says first you got to accept it. And the acceptance must be absolute. So you got to give an absolute, I hereby accept this and agree without anything else. You got to give an absolute acceptance. And then right after that, it says acceptance by performing conditions or receiving conditions. Then it says performance of a condition of a proposal or an acceptance of any consideration for reciprocal promises which may be offered with a proposal is an acceptance of the proposal, right? So performance of the proposal. When the proposal is accepted, it's $50,000 that they saying is due. Once it's accepted with an absolute acceptance, then it says that the proposal must be issued along with the consideration. So once you accept it, you got to pay the same amount that you have accepted as consideration for the acceptance of the value that you're receiving. And then it says promises and express implied. So it is insofar as proposal or acceptance of any promise is made in words, the promise is said to be expressed, and insofar the promises or proposal or acceptance is made otherwise than in words, it is said to be implied. So an express promise is one that's written on the instrument. An implied promise is when you just hold the instrument without expressing any rights, claims, or anything. So every month you've been given an implied promise. By the way you've been performing, it's implied that you agree to pay out your pocket, right? But according to the law, it says that an acceptance is either expressed or it's implied. I'm gonna go down to consent real quick, and then I'm gonna get up off of here. Read this last little thing. All right, so we got consent. Consent is two or more parties are said to consent when they agree upon the same thing in the same sense. So consent is when you agree to the same thing that the lender agrees to. The lender agrees that your account has a due balance of 250, and your acceptance and payment of the same is consent. Meaning he said that it's due to the account and you paid it to the account, which shows that y'all agreeing to the same thing. He issued a statement due to the principal. You accepted it and paid the same balance to the principal. So he said it was due. You made it payable. Remember, we read earlier, when something is due, it's bringing in a right for a payable transaction. So due and payable are interchangeable. If he issues something to you that's due and you accept it, then you have to pay what has been accepted as due. Because he's saying that this is due to your account, he's issuing you a statement that you can use against the balances that's due in the statement. If you accept the statement correctly, then you can provide another instrument for the due balances as an order to pay those balances against the account that is provided for. So the statement is a guarantee and the payment is a negotiable instrument. I'm gonna say it again. The statement is a guarantee once it's accepted, and the payment is what you provide from that guarantee. If you sign and promise to pay a debt, then you pay it with a negotiable instrument, but you got to send back your acceptance of that promise and then the promise to pay along with it. So now he's receiving that his promise has been accepted, and then along as consideration, you provided an instrument to the same amount of his accepted promise and paid it back to him. So now he's receiving back his note, showing that you accepted that value by accepting his note, which means that now you have the rights to the 50,000, and then he got an instrument worth 50,000 being paid along with the note. So it's showing that you accepted the note, did a conversion, took the money from the note, put it in another instrument, and then sent it back with the instrument as accepted. Let me say that again, just in case you didn't hear me. The lender sent you a note or made a proposal of an amount to you in an instrument. You signed and accepted the instrument by writing on it that you accept the proposal and signed, right? That shows that you accepted his offer. Then you took the amounts that the instrument was saying was due, and you converted that into another instrument, like a promissory note or order to pay, right? You took those amounts that you accepted on the instrument and you made them amounts payable in another instrument. And then you attached the instrument that you made from this instrument that you accepted, you put them together and sent them back. That's tender. That's how you make payment. Payment is made by accepting the amounts being tendered to you and then creating another instrument, putting those amounts in that instrument into that instrument, and then delivering it back as payment. It's called a conversion or a modification. But in order for you to issue a negotiable instrument, you got to be holding a right to payment. Hold on, let me say that again. You ain't heard me. In order for you to issue a negotiable instrument as payment, that means you got to be holding a negotiable instrument as credit. So if I got an instrument that says that this is credit to me, and I got another instrument saying that this is the payment, then they go together. This is the credit that's been approved, and this is the payment of that credit being provided. So I'm sending back my accepted credit agreement, and I'm sending back an instrument saying that every amount in that agreement that was approved, this is the order for it right here to pay. That's all it is. And it's really just that simple. It really is. It really ain't a whole lot to this. It ain't really a whole lot to this. It's all about you understanding that every instrument you receive gives you a balance. And that balance that the instrument is saying is due is a balance that you have to convert into another instrument in order to use it. You can't, only way you can use that due balance, you got to create an order for it. You got to create a promise for it. All right. You accept it through his instrument. That's the way you get to it. You got to accept it. Once you sign and accept, now you're holding that balance. Not just the instrument, but you're also holding the due balance, which gives you the right to use it now. If you're holding the instrument that's giving you the due balance, then why not create another instrument for that due balance and then pay it along with the instrument? That's how it goes. You're supposed to give an instrument for every instrument you receive. Every time you receive an instrument from a lender, you should be creating another instrument equivalent to that instrument, saying that this instrument is paying that instrument off. That's how you should do it. Every instrument you get, you should create another instrument to pay that instrument off by using the value, the due balances in the instrument you're trying to pay off through another instrument in order to pay it off. So you're accepting one instrument to convert the balances from that instrument into another instrument in order to use the other instrument you're making as payment for the instrument you've accepted. So it's a win-win situation. They're giving you the money. They're giving you the item to draw from. They're giving you the item to create the order from. They're giving you the item to create the promise from. They're giving you the item to do the assignment from. They're giving you the item to assess credit from. They're giving you the item to enforce your rights. You keep trying to go to the job and pay them instead of using the item or the value in the item that they gave. They already gave you a loan. They already gave you an item, and it already tells you how much is due. You just don't want to use the due balance. You keep on trying to pay it out your pocket. When are you going to stop going to work to pay your due balances in your contracts instead of acknowledging and accepting those balances and using? How long are you going to keep on working to pay those balances rather than acknowledging that they already are approved for you to use? How long are you going to keep doing this, man? How long are you going to keep on allowing them to take advantage? Tell me, how long does it take for you to realize that every contract you've signed already came with the balances that you needed already? Let me say it again for you. Every contract you've ever signed already came with the balances that you needed already. You defaulted on every last one of them. Every contract you ever signed tells you your due balance, and you never use it. A lease tells you the due balance. A mortgage tells you the due balance. A rental agreement tells you the due balance. A personal loan tells you your due balance. But they educated you wrong, though. So when you hear the due balance, you think you owe a debt. But the due balance came with the loan. So if you sign this agreement and it got a due balance stated in it, what makes you think you're supposed to be working to pay that off? Why you don't look at it as if this due, when I purchased this lease, according to my understanding, I also purchased rents with a schedule for those rents to be applied. Now, either you're trying to deceive me by saying I owe you these rents personally, or you're going to acknowledge that this lease that I purchased came along with a schedule of rents already scheduled in this lease. So if I'm issuing this lease back to you and it already got a schedule of rents to be applied and that was extended to me as credit, are those rents supposed to be credited for me? When I sign the lease, am I actually just receiving the lease, or is the lease a medium that's being provided to me that allows me to receive rents? I'm going to say it again. Is the lease being provided to me as a debt that I have to pay off, meaning I got to pay for the lease? Or is the lease being provided to me as a medium that can provide me rents? If I understand the lease correctly, maybe it's something that I can do with the lease and extract rents from it to pay off my land loan rather than pay from my job. if I really understood my mortgage, maybe it's a way I can extract from the mortgage every balance due in the mortgage and use that due balance to pay the mortgage off. If I change my perspective, understanding that credit is extended through negotiable instruments. So your perception is off. You're looking at a loan as a debt. All right. But the loan is not the instrument that you're receiving. The actual loan is the due balances that you're supposed to pay. When you sign a contract, the real loan is what they disclose. When you sign a contract, let me explain this to you. If you go to a dealer and you sign an installment loan contract, the real loan is the truth in lending. When you look at that contract and it says truth in lending and it tells you those numbers, that's the actual money right there. So that's the actual real value that you're receiving. But because it's interest, it's not like cash. They're not going to pay it out to you. They're not going to just give you money in your hand. Okay? Because interest don't work like that. Interest is usually issued by an order, or it's issued by a promise, or it's issued by some kind of process. Because interest is it's not money that you can hold. Interest is just value assessed. So interest is assessed value. It's not something, it ain't something like paper. You can't take interest and put it in your hand like this. Only way you can put interest in your hand like this is by creating an order for it. Now, if you create an order for the interest, then it can become in the form of paper. But when you first receive a contract, the interest is stated as the truth in lending. The real value that they're disclosing to you is the interest. When you sign a contract and they say this amount is due on this date, that's all interest that they're talking about. They're not telling you to pay them in cash. That's not what that is. When you sign any contract, all those due balances that they're saying is due, those are all interest. That's the other side of the ledger. You're receiving the debt on this side. So the amount you owe is on the other side, but you think it's on this side. You think it's on the same side that you're receiving the obligation on. You're receiving the debit on this side, but you ought to pay it with credit. You can't pay a debit with a debit. If you receive a debt as a debit, as a positive number, you can't use positive numbers to pay it off. That's not accounting. Accounting is matching principles. If I receive a positive loan at $50,000, I can only pay it off with a negative 50. Meaning I have to use the matching principle. I have to assess the credits, the unpaid balance, the negative balance, the unpaid balance, the negative balance, the unpaid balance, the negative balance, the unpaid balance, the negative balance. What do you think is unpaid? The unpaid balance, the negative balance. What is the unpaid balance? The other side of the ledger. You're receiving debt on the principal side. Principal is positive in number. Interest is negative. It's negative. So when you're looking at your contract and it's saying your first payment is due $255 on January, that's a negative number it's talking about. It's not asking you to provide positive payments. If you add a positive payment to that contract, you know what you're doing? You're increasing the principal balance of your loan. Let me explain to you what this is. When you receive a loan, the principal is the total amount that you have. If I give you a $50,000 principal instrument, we don't have no more than $50,000 that we're dealing with. That's it. It's $50,000. And that's the total amount of the principal. There is no more principal. The total amount of principal is $50,000. Now, what's due on that principal is interest. Interest is what's due on all debts, but you paying in cash. But interest is what's due on all debts. So if you sign a principal loan at $50,000, right? And you sign that, you're receiving the title The reason why you got to sign the debt is because the debt is the title to the income. Okay, principal produces what's known as income. Income is stated as a due balance on principal. Let me say it again, just in case you ain't heard me. Principal produces what's known as income. Income is stated in the principal as a due balance. So whenever you sign a contract, you're receiving the principal. But every contract states the income that must come into the contract. Let me say that again, just in case you didn't hear me. Whenever you sign a contract, you're receiving principal. Principal is the total amount of the contract. It usually tells both values. It tells the principal value, and it usually states the due balance, which is both sides of the ledger. So it's giving you, the principal gives you both sides. It tells you the principal amount, and then it tells you the due balance that's payable, okay? The due balance is the payable balance. It says due balance, but you can change it and stop saying due balance and start saying payable balance, because that's what the due balance is. It's the balance that should be paid to pay off the note. Whenever you receive a loan, every amount that they say is due is what you're supposed to use to pay it off. You're not supposed to be using other money. You're supposed to be accepting that instrument to get to that due balance. And then once you accept it, you use the due balance as consideration. Okay, you don't actually go to work to pay off no damn loan. That ain't what you're supposed to be doing. Okay, you're doing it wrong. Okay, every contract comes with both values already stated in it. It comes with the principal amount and the due balance. The due balance is income. You don't believe me? Look up principal and income. How does principal generate income? And you'll see exactly what I'm talking about. So every loan that you get produces its own income. And the income that's produced from the instrument is what the instrument has to receive in order to settle. So every time an extension of credit is approved, the payment schedule is already written in the instrument to apply back to the instrument to pay it off. That's why they ask you to repay it. They're not asking you to pay in cash. They're asking you to acknowledge the due balances and repay it back to the note. They're not asking you for cash. They're asking you to acknowledge the instrument in its due balances and then give consideration of those due balances back to the note. You don't have to pay in cash. All you got to do is accept what's due on the note and apply it back to the note. That's how you contract. You accept, assign, and pay. Why would you go to work to pay off something when you receiving a secured loan? You can look it up right now. A consumer loan is a secured loan. Google that shit right now. What is a secured loan? A secured loan is a consumer contract. A consumer is a protected person, an insured person. That's why you in debt, because you keep defaulting on your insurance. You keep looking at the insurance as a debt rather than insurance to cover you, and you won't use it for coverage. You keep defaulting. You're defaulting on the insurance. You're looking at your insurance as a debt. The insurance is what insures the debt. When you receive a mortgage, it already has an insured due balance on it, that it already ensured that this balance will be applied. Whether they collect it from you or you approve it to be applied from the actual agreement itself. But every agreement is already secured. It already comes with a scheduled payment payoff date. Every debt I ever purchased already came with its own payoff schedule. I didn't have to create a schedule to pay it off. It already came with a payoff schedule. All I had to do is accept the debt, acknowledge the amounts as credit, and then apply those credits for the payoff, meaning it already was set up anyway. When I signed the debt, it already had the scheduled dates for my rents to be paid. All I had to do was make sure that I acknowledged that the rents was part of the agreement. I accept those rents and then give an order or some kind of negotiable instrument to my landlord for the same rents that the agreement gave me, and saying this is the rents for the lease, and make sure that the instrument and the lease are one and the same, meaning that everything that the lease says is everything that the instrument represents. So now you can't separate the instrument from the lease, meaning you have to acknowledge that the instrument is the rents stated in the lease. I took another instrument and created rents for it. And then I tied that instrument to the lease. So now the instrument represents rents that the lease helped me generate. The lease gave me a right to rent. And because I'm smart enough to create a negotiable order, I created a negotiable instrument and it tied it to the lease. Why? Because this order came from the lease. The lease gave me the rights to create the order. Without the lease, I can't create the rents. The rents came from the lease. So the lease got to go along with the instrument because I got to prove to them where this instrument is coming from. Do that make sense? Hey, listen, man. Everything is already given to you, man. They give you everything already. You just don't understand commerce. Every loan you got is already secured. You already got both balances. Every time you sign a contract, you receive both balances at the same. Both of them. Matter of fact, they even giving you truth in lending disclosures. That's how crazy it is. They even disclose to you the APR, the finance charge. They tell you, and you still default. Still default. And they giving you the amounts, and you still don't understand the agreement. That's crazy. That's crazy. That's crazy that somebody can tell you how much you approved for and then give you an instrument showing you the amounts that you've been approved for, and you don't never use it. You never use, and you reading it and it's telling you how much you've been, and you never use it. Gotta be crazy, man. Gotta be, you gotta be crazy. And to think that the lender, to think that your credit is paid by the lender is ludicrous when the lender is the one approving you for the credit. So what that means, if I approve you for a $50,000 loan, that means that I got to accept a $50,000 order from you. Meaning that instead of you paying me in cash, you already got approval of $50,000 with. I approved you for a $50,000 personal loan, and it's already been approved. You've already received a copy of the agreement showing that I approved you for the loan. But instead of you demanding that the amount you was approved be applied, you'd rather pay me. Again, you'd rather give me $50,000 in cash to pay off the personal loan rather than you saying, wait a minute, didn't you approve me for a personal loan for $50,000? Okay, well, I accept this loan and this agreement. I accept the $50,000 that's been approved. And as consideration for providing me with this loan for $50,000, I'm going to pay the same amount received back to your order. Why would I pay you out my pocket if you just gave me a $50,000 credit? If you gave me a $50,000 credit, that means that you have to accept the $50,000 order from me. That's all that means. If you approve me for a $3,000 lease for a whole year, that means that you have to accept an order for rents of $50,000 as credit, meaning that you can't deny me the rights to have $3,000 as a reduced balance with you because I have a credit of $3,000 with you. How I know I got a credit of $3,000? I got a lease right here that's been approved for $3,000, so that's $3,000 worth of credit because we're operating on credit terms. So I have a lease that says that I have a $3,000 credit with you. All right, before you try to collect these rents, you need to first acknowledge the credits that you owe me first and apply them. Once you apply those credits, then we should settle with each other. Why would I pay you rents before you give me the amounts you promised? See, y'all gonna have to wake up. You got to understand that the lender can't collect before providing what he promised. How you gonna pay something you ain't got yet? How you gonna give him credits if he haven't gave you an instrument saying this is the 50,000 that you were approved for, and he give you a $50,000 check saying this is 50,000 for the approved balance of the agreement. He didn't do that. He told you was approved by Bank of America, but he never came in with a check from Bank of America and say, hey, here's that 50,000 Bank of America approved you for. How you want to use it? You want to pay it to us? Or... He never did that. Instead, he just told you was approved, withheld the balance from you, made you sign the agreement, sold it to the bank, and then start collecting from you and kept the money that the bank provided him when they approved you, because the bank approved you for 50,000, and the lender is supposed to reduce your obligation up to 50,000 because you got an approved credit for 50,000. But instead, he's going to play on your intelligence, hoping you don't understand that you have a $50,000 credit that's been approved that you can reduce with him. Instead, he's going to collect that credit from you, using the bank as another party to help him do his scheme. See, really, in actuality, when you get approved for credit, the lender is supposed to allow that credit to be applied. So if the bank approved 50,000 and then you sign the credit agreement, when you give it to the lender, he was supposed to accept that agreement as an extension of credit and then reduce your obligation up to the 50,000. But he didn't. Instead, when he received the agreement, he acted like he didn't receive anything of value from you, assigned it to another, and then tried to collect on the value as if you owe him for a loan, when really he owed you for a loan, and he should have applied the amount he approved you for to reduce your obligation with the bank, but he didn't do that. See what I'm saying? So understanding that anytime you get approved for credit, you have a right to reduce that amount with the lender. If I approve you for $3,000 and I give you an instrument, you got a right to use that instrument to reduce $3,000 with. Meaning that instead of you paying me for this instrument, you can say, wait a minute, this instrument is evidence that I have a $3,000 credit. I hereby accept the credit and hereby pay it to your order and demand that you apply the $3,000 that's approved as credit for this agreement. Why would I pay you $3,000 if you just approve me for a $3,000 lease? Wouldn't it be more logical to acknowledge that I got a $3,000 credit from the lease and then demand that it be applied rather than pay him out my pocket? Why wouldn't I assess the $3,000 that the lease is granting me? And if he's the one that gave it to me, then that means that he's the one responsible to make sure that the credits that I am entitled to are applied. So you're paying the same one who should be reducing your debt. You're paying the lender when the lender should be providing the same amount. That, how you gonna pay the lender credit that he never gave to you to pay him with? If he approved you for credit, in order for you to pay the credits, you gotta first receive them first. Think about what I'm saying. How you gonna pay the rents to your landlord if you ain't received the rent from him yet under his lease yet? He offered you a lease with rents, but in order for you to pay those rents that the lease is saying is due, the landlord would have to actually provide those rents to you. Once you've accepted the lease, he has to either give you credit of that amount, or he either has to provide those payments every month to reduce your lease, right? Because you have a right to use the rents that the lease provides as a reduced balance of credit, meaning that those rents are credits to you, meaning that when you purchase that, those rents became credits upon acceptance of that debt. So now, instead of you paying rents to him out your pocket, you're not going to do that. You're going to acknowledge the lease as an extension of credit. You're going to accept the due balances of rents as credit received, and then you're going to give them an order or a promise or something in order to convey those rents back to them and attach a copy of the lease as proof of your insurance or your guarantee to use rents. See, you got to change your perspective. You got to change the way you see transactions, the way you see credit. That's right. And you can use full faith and credit of the United States. You can use the full faith and credit. You can receive a contract and endorse it to the United States for full faith and credit. You can acknowledge it as an obligation of the U.S. government under Title 31-1501 or Title 1301. So I can easily say, I can acknowledge this debt as a United States debt received from a United States agency, T-Mobile, as the holder of this obligation of the United States under Title 31, Title 1301. I I hereby acknowledge that the United States is responsible to pay this obligation, and under 12 USC 411, I hereby claim the full faith and credit under this credit agreement and pay all obligations to the order of the United States for credit to the lender for settlement and closure. So I just draw, you can do it like that too. You can draw against the government. You can identify the debt as a government obligation, and then you can assign it to the government to fulfill the terms of the agreement. You can assign any contract as long as it's over $25. It got to be over $25. It can be assigned to anybody. Like I said, anything issued to you can be assigned to another for collection and payment. If I offer you rent in a lease and you accept my offer, you can transfer my offer to another person by endorsing it to them and saying that you're giving them the rights to collect my offer. So now, if I give it to another person, now he can go back to the original lender. He can say, hey, look, I got a copy of an installment contract from Isaiah Joaquin Bay that's been assigned to me for collection and payment. Here's a copy of the assignment from Isaiah Bay and a copy of the instrument in my possession. As the holder on behalf of Isaiah Joaquin Bay, we hereby claim the rights to collect every due balance under this agreement. And now that lender who I assigned that contract to can go after the original lender who lend me the value and collect what I'm promised. Okay? But you gotta do an assignment for them to go collect that for you. You gotta appoint an agent to collect what another agent is offering you. So if he's offering you this, you assign it to another agent to collect it, a financial agent. You use it just like a check. If he's giving you a right of credit, that instrument is like a check. It's like a negotiable check. So it can be assigned for the value that it generates. So if it's promising 50,000 in installments, and you want those installments to be used for your benefit, and he's already saying that he will provide them, you gotta deposit that instrument to another party for collecting the instrument, so that somebody else can act on your behalf and collect what you're entitled to. Because in this system, they don't allow you to do self-enrichment. So in order to not self-enrich yourself, the same rights that you have as the one under those rights, you have to give that same right to somebody else to act for you. That's part of how they set this thing up. So nobody can actually try to self-enrich themselves. So whatever rights you have, you need to assign them to somebody else and give somebody else the rights to act in your place. Whether that's about pay to the order, assignment of rights, it doesn't matter. You got to give whatever rights you hold to somebody else for the performance of that right for you. Okay? And that's the way this system works. It's always worked like that, and it's set up like that. You know what I'm saying? And anything you don't assign for collection or payment, or you don't transfer to another person for collection and payment, when that obligation becomes payable, meaning on the due date, then it's due against you because it's in your possession. Anything you hold that becomes payable in your possession, you have to pay it because it's in your possession at the time it became payable. If it's due, it's not payable yet. So while it's due, you can do what you want with it while it's due. But when it becomes payable, it's a wrap. You got to pay it because it's in your possession and it's payable. Okay? So remember that. The reason why you got to pay bills every month is because you hold those bills. And by the end of that term, when that bill becomes payable, now they want to set your lights off. They want to do stuff because the bill is still in your possession. Now, if you would have assigned that bill or paid that bill to somebody else and it would have been in possession of somebody else, then that lender would have got a notification from another lender or another creditor of a right that you claim. Now, he's on the hook because he's the one that gave you the right to that promise. So if you accept the promise and use it and give it to somebody to collect for you, and then they go after collecting the promise that he made to you, he got to pay that shit because he's the one that made the promise that you've accepted and transferred. All right? So the only way he get off the hook is when you don't assign your rights against him. Meaning make him perform. Make him do what he's promising to do. Stop holding his promise, and then it become impayable against you. Now you got to pay his promise because you held it. Make his ass perform. Make him do what he's supposed to do because that's your right. And when you got right to do something, you do it by all means. You don't allow nobody to deprive you of a right, understanding that every contract is an assignment of a right that you have. You have the rights to accept and assign that instrument for the amounts that it's saying. Okay? Never allow a lender to become, never allow your creditor to get off the hook. Let me read this for you real quick. We're going to the Fair Debt Collection Practices Act. I'm going to show you something. Check this out. Because a lot of people, like I said, a lot of people teaching it wrong. Now, they'll tell you you are the creditor. Now, you are a creditor. I'm not saying you're not a creditor. But when it comes to doing contracts and agreements, you don't act as a creditor in a contract. You act as a beneficiary. All right? So for everybody that keep telling you when you enter into a contract, they keep trying to tell you the creditor, they let you know they don't know what they're talking about. The creditor is the one responsible to make payment. Okay? You're the beneficiary. Okay? You're not the creditor. You're the beneficiary. Okay? Let's go in. So we're going to go to Fair Debt Collection Practices Act. I'm just going to read something. All right, so it says the term consumer means any natural person obligated or allegedly obligated to pay a debt. So one thing we know for sure in the Fair Debt Collection Practices Act, the consumer is not acting as the creditor. The consumer is more or less the person that's allegedly obligated in the agreement, according to the Fair Debt Collection Practices Act, to pay the debt. Okay? But some way, somehow, people keep saying that the consumer is, in fact, the creditor. The consumer is not the creditor. The consumer is the issuer for value. The consumer gives the value to the debt, but he's not the creditor. The creditor is the one who creates the debt and issues the debt. That's the creditor and responsible for the debt. The consumer is not that. The consumer doesn't issue the debt. He issues the value of the debt. When the debt is signed and the value is attached, that's when the consumer issues. He doesn't issue the original debt. The original debt is issued by the lender. Okay, so get that right because a lot of people got that wrong. So it says the term creditor means the person who offers. So when we go to the Contract Act, right, it says that an offer is a proposal. Whenever a proposal is made to you and you receive it, it's considered to be an offer. So if you go and you put in an application for a lease and you receive the lease is considered as an offer of rents to you. They're offering the lease to you as a medium to exchange rents to you because that instrument can provide rents. If you know what you're doing, you can leverage that instrument and gain rights to the rents that it's producing. Okay, but you got to be competent to do that, right? So the creditor is the one who offers or extends credit, creating a debt. The consumer doesn't create the debt. The debt is created from the lender. He's the one creating the instrument. He's the one making that instrument up. The consumer, you ain't have nothing to do with that. You didn't sign, you didn't write nothing on it. You didn't put a term into it. You didn't do nothing. All consumer debts are already secured obligations, meaning they already come prepaid, pre-secured already. That's why you don't have to give your rights. Your rights are already secured in the agreement. As a consumer, they issue secured transactions already to your benefit. It's already beneficial to you. You just got to understand what to do to get that benefit. It's already a secured transaction. So the term creditor means the person who offers or extends the credit, creating the debt, or to whom the debt is owed. So That's why you end up paying the creditor, right? Because he's saying that you owe the debt to him. You owe, he extended credit to you, and he's basically saying you owe him payment for extending the debt. But people been telling you that when you read the Fair Debt Collection Practices Act, this term that we read in creditor is referring to the consumer. That's incorrect. This is talking about the actual lender. It's saying that the lender is the one who extends, creating the debt to whom the debt is owed. So actually, it's his debt. He's the one that's supposed to pay it. It says, but such term does not include a person to the extent he receives an assignment or a transfer of a debt, the consumer. Meaning that at the time when the lender creates his debt, he issues it to you. He assigns that debt to you, right? To you as a person. So, but it says right here, but such term does not include the person to the extent that he receives an assignment or a transfer of a debt in default solely for the purposes of facilitating collection of the debt of another. So, being that the original debt is actually belongs to the lender, it's his asset. And what he's trying to do is loan it to you. He's giving you a right to pay the asset off and buy it. But you got to buy it with the amounts that he's providing to you. If you don't buy it with the due balances that he's giving you, then you never buy the debt. You can offset it, but the debt would never come back to you because you didn't buy the title. The title remains in the lender as long as the amounts that are supposed to be paid to have title to the debt have not been paid toward the title. So you can pay in cash, you can pay in any other form. You would not get your title back. You know why? You would not get your mortgage back. You would not get your lease back because you didn't buy it with the right value. If you pay with the correct amount that the agreement calls for, and you apply the correct balance to that debt, once that debt is reduced to zero, he has to release the title to you, meaning that you bought the lease now. Meaning that every due balance of rents were applied correctly to reduce the original principal lease. So now, since you've applied the rents in every month, the principal amount, which was $3,000, is getting lower and lower because the matching principal is coming back into the note and reducing it back to zero. And all the way down to the note zeroes out. So every month you get a reduced balance of credit that reduces the original extension of credit by using the other side of the ledger, the due balances, back toward the original principal note. Now, once that note is fully exalted and paid off to zero, now you own the note. Now the lender has to what? Return back to you the title, which is the original contract you signed. But it got to be paid for. As long as it's not paid for, he gets to keep the title. That's why you've never received your lease back. That's why you've never received your mortgage back. That's why you never received the installment loan contract. Even though you got the title to the car, you never received back your loan agreement. Why? Because you never paid. It was a loan to you. If you would have paid it off, then you could have bought the agreement. Then you would have owned the actual property. See, you got a misinterpretation. So the reason why the creditor is the one who extends or creates the debt and whom the obligation is due to, but not the person who receives an assignment or a transfer of debt. So you're receiving an assignment of the lender's obligation to provide credit to you that you're requesting for. You're requesting for an extension of credit, $50,000. The lender is providing you a debt instrument, right, for the $50,000 that you applied for. But the debt is in default. Why is it in default? Because the lender is not actually paying that balance to you. He's on the agreement. It says that the amount is due, but you've already been approved for it, so it shouldn't still be due. It should be paid now. It should be payable to you now. It was due when you were applying for it, but then once it got approved, and then the lender draws up the instrument for the amount that you were approved for, he was supposed to pay that balance to you. He was supposed to provide payment of the approved balance, but he didn't do that. Instead, he wrote the instrument up and withheld the balance from you and said that it's a due balance and gave you an obligation to perform
in order to receive that balance. So he split it. He took the principal note at the time when he received it, and he split it. He took the principal, he put it over here. He took the due balances from that principal and put it over here in this account. And then he waited to see if you were to give orders on how to apply this amount toward this amount. When you didn't give any orders to apply this amount toward this amount, he considered it as a default. Now, this amount, this is the installment contract. This went over here. This is the due balances, the APR, the interest rate. This went over here. All right. The lender is waiting on you to tell him to take this balance, the due balances, the interest rate, and apply it back to this note. When you don't do that, he says that you default. You know what happens in default? Let me explain to you what happens. When you default, right? Say for instance, you receive a loan. This is the principal, this is $50,000. But it has due balances scheduled in it of the same amount, $50,000. So you got a $50,000 note and you got a $50,000 schedule of payments in that note that has to be paid. So the note is worth $50,000, but you also got due balances worth $50,000 too. That's not applied yet. They'll be applied later. But they are evidenced in the agreement, meaning they're telling you about those balances at the time when you receive the note. So you'll know of the other balances and when they're due. Now, in your mind, you might not think that you're holding two balances, but you better wake up and realize that you're holding two balances at that time. One is in your hand and the other one is being disclosed, and you have to pay that, the other. Okay? Understand that. You got one in your hand, but the other one is disclosed in the item that you're holding. It's telling you the amounts, the dates, but it hasn't been applied yet, meaning you're still holding it because it's interest. You're holding it because you're holding the instrument, but it hasn't been applied yet. Understand what I'm saying? So if you sign an instrument, that's proof that you receive interest, and that's proof that you receive principal. That's proof that you receive both back. If you deliver that instrument to the lender, he's going to only acknowledge that he only received the principal. That's what he's going to say. He said you deliver a partial payment. The reason why it's partial is because you only gave the principal amount. You didn't pay the interest with it. Whenever you deliver an instrument, you must pay the interest associated with it in order to fully pay the loan off. If you just give back the instrument and sign it, that's partial payment. You're only making a principal payment, but you're receiving interest and principal. So every instrument should be issued with an order for the interest that is due. You should never issue an instrument unless it's issued with an order for the due balance. Every instrument should have an order or a direction for the due balance. You never issue anything without an order for the due balance, because every instrument will always have a due balance. And that due balance has to be directed. Okay? Now, what I'm going to say. Yeah, I think I said enough. I think I nailed on this thing enough for you to get an understanding of what I'm talking about. So you can understand that all your debts are secured already. You're receiving secured debts. Your debts already come with payments already in them already. You just got to learn how to use those payments. Those payments are already evidenced. You can't show me one contract that don't have a payment schedule. Show me your lease and I'm going to show you that you already got payment of rents. Show me your mortgage and I'm going to show you that you already got a payment of installments in there. Show me any agreement and I'm going to show you that when you purchase that agreement, you also purchase payments that should have been applied. Now, in your mind, you might have thought you're supposed to be paying it out your pocket. But I'm here to tell you that every amount that instrument says that you think you're supposed to pay, the lender is supposed to pay. He's the one supposed to pay that, because those are the credits that you were approved for. So why are you paying credits that you why are you paying the due balances if the due balances were the credits that were approved in your agreement? I'm gonna say it again. Why are you paying the due balances, the rents, the installments in that agreement out of your pocket if that agreement was extended to you as credit? That means that every balance that's due is credit. It would have to be credit because the agreement was extended to you as credit. So you can't receive an agreement as credit and then end up having to pay in debit. That wouldn't be logical. If you receive an agreement as credit, then you have the rights to assess the credits that the agreement provides and demand that the lender reduce that credit for you, or that he apply that credit as a reduced balance rather than collecting from you something that should be reduced for you. Rather than collecting something from you that should be reduced for you. When you say I own the debt, I'm the owner of the lease, I'm the owner of the mortgage, you're not saying you the owner of just the item, you're saying that every due balance is yours too. Meaning that when I signed this agreement, I didn't just purchase this agreement, I also purchased these balances that was in this agreement. Now, I'm acknowledging these balances as credits or as income due to me on the asset that you're holding. And I'm verifying that I am the payee stated in the document who is entitled to receive these due balances. And then I attach verification to prove that the legal person that they're saying the amounts is due to is actually the natural man using that identity as his legal identity. Now that you verify that the legal person that the amounts are due to is actually a man acting through that person, now you know who the true party, who you're supposed to pay to. Now you got to pay me because now you can't assume that you're charging an account no more. You got to verify that that legal person is actually a man asserting services through that account principal. So that's the way it goes. You got to verify the identity of the debtor, the borrower, the leasee. All right. You got to verify the leasee's identity. And then the leasee, once he verifies his identity, he can claim his rightful rights to the balances that were provided to him on account of credit or an account of rights. So I just wanted to show you that, right? So what you actually have done is you received credit from a creditor who is obligated, who the obligation is due to. The creditor is the one who is obligated to provide the due balances under his offer. But the consumer has accepted that extension of credit in default solely for the purpose of facilitating collection of such debts for the lender. So the lender is supposed to be the one paying the debt. But when the consumer signs unaware of his rights, then the roles switch. Now the lender gets off the hook and doesn't have to provide the due balances that he offered. And the consumer accepts the lender's position and stands in the place of the lender now because the lender transferred the title to the consumer. The consumer received the title and all the obligations shift to the consumer. So now the lender doesn't have to pay anything unless the consumer demands and accepts and makes the lender pay. So what happens is at the time when you apply for a debt, the obligation is the lender's obligation because he's the creditor and he's the one offering those balances to you as an extension of credit. Once you sign that agreement, right, then the lender is obligated to provide credit to you, right? But what happens is by law merchant, when the lender delivers the title document to you and you sign it and give value, all right, what happens is there's a shift in authority. The lender was responsible as the creditor to provide every balance that the instrument says is due. But when you sign, you accepted the lender's obligation. Now, by law, when you sign, the title shifts to you now. So now when you sign that agreement, the lender is no longer holding the title anymore. He's no longer responsible once the title transfers to another. So once you sign it, now the lender was supposed to pay you. He was obligated because he's the one who issued it. But when you signed, you took over his responsibility. If you're unaware that the title is transferring to you and you're becoming responsible, then you might hold the lender's obligation, unaware that the lender is the real debtor and that he's the real one responsible to provide these amounts in this instrument. But because you are unaware of that, when you signed that debt, you took his place and then you kept the debt. So now the lender assumes that he can collect from you now because you accepted being in his position without any discrepancy. So now he's billing you and trying to collect under the title that he transferred to you that you've accepted paying. All right, because you took his position once you signed, and then you became the new debtor or the new person to pay under that title. See, that's where the problem is coming in at. When a lender delivers the title to you, you're supposed to accept the lender paying you, not you paying the lender. Vice versa. And they get away with this because they know that most of us don't understand contracts. We don't understand assignments, transfers, or none of that. You know, that's why you don't understand that every time you get approved for credit, the reason why you end up paying is because once he approves you for the credit and he transfers that document to you, he's also transferring his rights to pay you because he's the creditor. He's the one responsible for payment. But every transaction, the title shifts to the consumer at the beginning of the contract. Every time you enter into a contract, they always deliver the title to you. You go open up a bank account, they're going to give you the signature card. It's going to be in your hands. So the title is now in your hands. When you sign it, now you've accepted the title. So what that means that you and the bank have switched roles now. So now the bank is assuming that you agree to pay everything because you took the title from the bank and signed it and accepted the title and then default. You didn't make the bank perform what it promised. So now you're in the bank's position. So now every time you do an EFT, an overdraft, or anything, the bank make you pay. Why? Because you took the title from the bank at the time of opening the account and kept the title in your possession. 9/10 of the law is possession. So that means that if you hold the title, you're responsible for everything. Facts. Facts. It's facts. You're holding the lender's obligation. Every time the lender is responsible to provide payment and he delivers the item to you, you never assert or collect the obligation against the lender. Instead, you hold it and then it becomes payable in your possession. And now the lender is you and the lender on the contract. So if it's payable and it's in your possession, then the lender get to collect from you because the title is in your possession. And you know why you be like, well, damn, brother Isaiah, if he gave me the title and I signed it and the title became in my possession because he delivered it to me, now the title was in my possession and I signed it, then I give it back to him. Shouldn't the title transfer back to him once I deliver the instrument back to him? It should. But you know what he does? Once you deliver that item back to him with a blank endorsement, he makes it payable to himself. He signs over your blank endorsement, paid to the order of himself. Now the instrument is payable to him. So that means if you're the signer and issuer of an instrument payable to me, that means that you owe me money. So that's how he gets you. He issues everything to you, give you a right to accept and use the value. When you fail to use it and part way with the instrument, you give it back to him, blank endorsement. He accepts it back, makes it payable to his order, and he collects the amounts that the instrument is providing. Why? Because evidently you didn't want the amounts. You didn't want to use the amounts because you gave them back to him. with a blank endorsement without any direction or any orders for those amounts that were approved for U.S. credit. Instead, you looked at these amounts as debts rather than approved credits. Every time you enter into a contract, you're going to get approved for credits. Credits will always be stated as due balances. If you're incompetent, you're going to think that those are debts that you owe. You're not going to look at the due balance as credits approved that you can use, and you're going to default right there on the spot because you're not going to use the approved balance. You're not going to use it because you think it's debt. You think it's something you owe and you got to pay 30 days later. You don't understand that at the time when you sign that contract, every due balance is the credits that you should be using. You should be, that's why it's called a due balance. It's due to be used. But you want to let it get, you want it to become payable first. You'd rather for it to become payable. That way it can't be used. See what I'm saying? It can only be paid. So understand that when something is due, it's due to be used for whatever purpose. So when you receive a due bill, you receive a due whatever, it's giving you an opportunity to use that due balance, to accept that due balance, to transfer that due balance, right? Because the balance is, the money is stated in the instrument, just like when you a negotiable instrument is just a medium for exchanging value. In order for me to receive $250, they issue a medium stating that $250 is due. They don't actually give you money like cash or anything like that. They transfer an instrument stating the amount of monetary value to be used. And then you, the one holding the instrument, creates an instrument to convey that monetary value from that instrument to another. So if I got a bill for $250, then I can convert that bill into something payable in $250. All right, y'all. Well, I think I went over enough credit terms that kind of help y'all get a better understanding. If you'd like to learn more about how credit works, if it's anything about anything that I said on this live that you're not certain, you're still kind of puzzled, you still get a consultation with me. You can go to buildingbetterminds.info and get a consultation. Or I could give you my cash app, and today I could give a $75 payment for an hour consultation. Only for today. You know, I usually charge for an hour, I think like $250 to have a consultation with Brother Isaiah. But for today, I will do a favor for anybody that like any of the information that I just was going over and you want to learn more about it, or you got questions and you need more info, or you got certain documents and you want me to, go over those documents and discuss your payment terms, you can most definitely today get a consultation at $75 for an hour. You can make a cash app to Isaiah Jakeem on Cash App. It's the $sign Isaiah, ISAIAH. Jakeem is JAKEEM. Okay, so you'll make a $75 payment to Isaiah Jakeem on Cash App. When you make your $75 payment, put your phone number in the Cash App notes, and I will give you a call for your consultation. If you don't receive a call, you will receive a return of your money. That will mean that I've probably done too many of them and I'm returning the payments back to those individuals. All right, so first come, first serve. I don't know how many consultations I will do for an hour, probably only a few of them. So first come, first serve. if you get in there first and you one of the lucky first 3 or 4 people that I do a consultation with, because I ain't, you know, you got to think about it. Each consultation is an hour, so that's an hour per person. So, you know, I'm not going to do no 12 hours, no 11 hours, none of that. So if you're trying to get this, you better be one of the first 3 or 4 people, because other than that, I probably ain't going to do no more. I probably only do like 3 or 4 people for $75. Okay. And this is only for people that really need help, that really need information. If you've been wanting to, you know, talk to the brother and you've been wanting to get in contact with me, this is your opportunity now to get a chance to have a one-on-one with me and go over some of the information that I've been discussing to get a better, a fuller, well-rounded understanding, and maybe even more information about the process. So, like I said, if you're looking for that, I already told you the cash app. Put your phone number in there, and I'll give you a call. Once I get your information and I get your payment, I give you a call. If you don't receive a call, then you should receive your money. That means that I did too many already. So just keep that in mind. First comes, first serve. I thank y'all for y'all time, for giving a listening ear. My thing is, when I come on here is to bring enlightening information. I don't want to never come on here and not give you something. If I come on here, I want to make sure that you receive something that you can use for you, your family, and for your benefit, because that's what it's all about, man. It's about us helping each other, because we see the system ain't helping us. We see what they doing to us and how they playing us. You know, we got to be our own protectors, our own keepers. So as a brother to my brothers and sisters, this is a way of me extending my love to you. This is a way of me giving my consideration to you. This is also a way for me to give donation and charity to the people without charging. You see what I'm saying? So everything I just went over, I gave to you for free, charge. I didn't charge you a dime for it. Only thing that you were charged was attention, was to pay attention. Other than that, it was free. So this is the way that I give out my charity. This is the way that I give back to the people, is when I come on live and I give away information that I know is very vital and important to the structure of the system that we live in, and I don't charge you for it. All right, so understand that this is Brother Isaiah giving his charity. So thank you for your time. Thank you for all your support, and I look forward to seeing you guys again in the next live. I will constantly keep bringing new information, new processes and different things to the forefront for the people. All I ask is that you share my lives out, give me the likes. That's all I ask for, you know. I don't ask you for a whole lot. You know, just give me some consideration, give me some kind of value in exchange for the value that I'm providing to you. And we should be good to go. But with that said, man, I'm gonna bring this to a finalization. Again, for anybody that want to know, that's the Cash App. If you want to get a consultation for an hour, only for today, it'll be for $75. I may take like 2 or 3 people. I'm not gonna do too many people. So if you are one of the lucky individuals who able to reach me first and get the consultation, I will be holding these consultations here as soon as I get up off of here. So if you're looking forward to, you know, going over anything I just went over, and you need an hour with me to, you know, fully pick my brain for information, this is your opportunity today. That's Isaiah Jakeem, Isaiah Isaia Jakeem, Isaiah, and Jakeem is JAKEEM, $ on the Cash App. So it's $ Isaiah Jakeem. Okay. First 3 or 4 people will be the lucky contestants, and after that, I'll be shutting everything off. So don't feel some kind of way if your money come back. All right. Peace and love. I thank you for your time. Y'all have a blessed, y'all have a wonderful day. And I'll catch you in the next matter.